Yes.
Adjournment request, if any, from item number 1 to 5.
Lordships, may I pray for an adjournment virtually?
Yes.
Lordship, serial number 4, Lordships, it's a matter relating to constitutional validity of section 16(2)AA. On the
Yes.
last occasion, I had advanced my submissions, Lordships,
Yes.
and the matter was admitted. It is to be heard, Lordship. Any Tuesday is convenient to your Lordship. Any day, any Tuesday, Lordship, it would be. I would travel down.
Any difficulty today?
Lordship, today, Lordship, it's a constitutional validity matter, and I have a prefix matter at Ranchi High Court where I am already appearing. I would travel down physically, Lordships, to argue this matter, Lordships.
When do you want it?
Lordship, I have asked my learned senior opposite side. Any Tuesdays or Thursday would be okay, Lordships. Coming Tuesday is also okay to me.
No, coming Tuesday would not be.
Lordship, after 21st of August, Lordship. I may bring for the response.
All right. Sometimes in August. Give the date.
After
21st.
21st of August.
Grateful to your Lordships. Grateful. Much obliged.
May I please, the Lordships? I'd like to mention a matter for urgent listing. It's a writ appeal.
Urgent listing you mentioned after all the adjournments motion.
Item number 6 to 15. Adjournment request. Yes. Item number 6 to 15. Adjournment request, if any. Item number 18 to 25. Adjournment request. No. Any other request?
Yes.
Well, it's a very small matter. Well, I'm praying for listing of a review matter. It was heard and order was reserved on 12th of December 2000.
Review of which judgment?
The review of a division bench order passed earlier by a division bench of this honorable court. So it was heard finally from both sides. An order was reserved on 12th of December 2023. So page 3 may kindly see minutes. Now Honorable Justice Pathak has demitted office and he has been appointed as a Honorable Judge of the Odisha High Court.
Yes.
The matter has to be go to some other bench. It stands released from the bench. So I'm praying, my lords, any convenient date next month, subject to my lords. Because a bench will have to be constituted, my lords.
Let it be placed before Chief Justice of the Additional. All right, we'll have it constituted.
Obliged, my lords. Grateful.
You will be informed about the date.
Grateful, my lords. Obliged.
Number.
May I please, the Lordship, my lord. I beg to mention item number 24, my lord. I am appearing on behalf of M. Hussain, my lord. His wife is admitted in hospital. Only this matter may be fixed after 2 weeks, my lord.
As prayed for on behalf of the appellant, re-notify on next date in August.
Obliged to.
19th. 19 August.
May I please, your Lordship? My lord, I beg to mention for listing of a custom reference case, Lordship. Lordship, it was last listed on 4/6/2025, Lordship, and thereafter notice was issued after 4 weeks, Lordship. So kindly on 31st of July, Lordship.
That we cannot ensure. 4 weeks, it shall be listed. If it is
Lordship, it already, Lordship, more than 6
have it
weeks.
listed.
More than 6 weeks already gone, Lordship, but it was not listed.
Give the number.
Yes.
Give the slip and the number.
Obliged.
Your Lordship, I beg to mention a writ petition for urgent listing for tomorrow, Your Lordship. My matter, Your Lordship, relates to due to non-repayment of Lordship EMI against the
Non-repayment of?
EMI, Your Lordship,
Yes.
12 monthly installment, yes, against the home loan, Your Lordship. Somehow I defaulted, Your Lordship.
Yes.
Then my account become NPA, Your Lordship. Now my prayer before the bank authority, because the bank authority already taken over my possession of the secured asset, Your Lordship. Now my prayer before the bank authority is to convert my NPA account to standard asset, Your Lordship, as per RBI guidelines.
It's not on Monday. It will be listed.
Is-
When have you filed it?
Yeah, it was tomorrow, Your Lordship, because
When
my
have you filed the petition?
Lordship.
When have you filed the petition?
Yesterday, Your Lordship, yesterday.
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 It will be listed.
Uh,
Keep it on Tuesdays.
Your Lordship, if Your Lordship, with due respect, Your
Tomorrow
Lordship,
there is some problem. We have other matters lined up.
Monday auction is going to be held, Your Lordship, of the
We can't
secured
help
asset,
it
Your
now.
Lordship.
You tell the court that you have challenged it. Tell the authorities that you have
Lordship,
challenged it. If
Lordship.
they wait, if they wait, it's all right. But then you filed only yesterday,
Lordship, Lordship.
Tuesday.
29 July.
If it is defect free,
It was defect free, Your Lordship. On Monday, Your Lordship, kindly with respect. Lordship.
Monday we cannot. Maybe Tuesday, Wednesday.
Tuesday or Wednesday.
Yes, Lordship.
29 or 30. Yeah?
May I please, your Lordship? May I please, your Lordship? To make a mention of a matter I happen to be a district and session judge in the state of Nagaland.
Yes.
I was a disciplinary proceeding was drawn against me under the service rule. But during the pendency of the service rule, I was given a compulsory retirement under the Nagaland service rule. So that has been challenged in this division bench. It has not been listed till now.
It will be listed next week.
Next.
Next
All right.
week, it shall be listed.
Fine.
Give your slip and
All
the
right.
number.
Sure.
Please, Your Lordship. I'd like to pray for urgent listing of this writ appeal. The appellants were forcefully and illegally removed from the possession of land. And
When did you file your petition?
21st.
Next week.
Uh,
Next week.
You get it.
Take the dates from the courtmaster.
Daily list for orders, item 1.
Yes.
Please, Your Lordship, in the earlier occasion, respondent number 2 and 3 were directed to place instructions regarding the revised PPO order.
My lord,
Can you place the last order? Who is Guru?
Mr. C. Borwa, Learned Standing Counsel,
My lord, I'm appearing on behalf of Accountant General A.N.E. Assam, my lord. Last occasion, it was in 16/7/2025, I was directed to bring instruction. Accordingly, the instruction is brought, lordship only. This is written to me. With due permission, I'm placing before lordship.
Now, there's something which has to be paid to a retired chief justice.
Yes,
retired
that
acting
is,
chief
I
justice.
have brought instruction.
All.
The instruction, I have brought it here, my lord, about the domestic help allowance. This is not paid by the, this is paid by purely High Court, my lord. Our High Court rules are there, it is also enclosed here with. They are retired chief justice as well as judges. They are entitled, their lordship, others are getting also. Even I have confirmed for other judges also, they are getting, my lord, it's not there. Bank नहीं होगा.
Mr. Bora Gohain is here.
Order?
Bora Gohain. Yes.
I have given him. I have given one copy to him. Petitioner, I am giving to bank also. If required, originally you to him, you know, if required, I'll place.
Yes, it has to be given to the High Court.
I go to.
The Registrar General of the High Court is permitted to be pleaded as a party. They are permitting you to implead Registrar General as a party.
he is a party.
He's a party.
He's a party. Respondent number 4, Your Lordship.
Let the response of the Registrar General of Guwahati High Court be filed by the next date. If the outstanding amount against the head of domestic help to former Chief Justice and former judges of Guwahati High Court rules 2020 has not been paid, effort should be made to clear the payment at the earliest. List this matter again under the same heading on after 2 weeks.
Highly obliged.
11.
Your Lordship.
Item number 2.
May I please, sir?
Yes.
Normally, an order granting prosecution sanction can always be tested before the trial court. But here is a case where it is, in my humble submission, it is hit by Article 14(1). The facts are like this. In fact, my lord, the contentions are recorded by the learned single judge at para 4. If your lordship will kindly have that, sir. Page 22, the impugned judgment starts.
what was contended before the learned single judge is recorded paragraphs 4 and 5.
Yes.
Para 4 at page 24.
Yes.
Mr. So-and-so, for the petitioner submits that the impugned prosecution sanction in respect of the petitioner is challenged primarily on the ground that several aspects that were considered to be germane and relevant for declining the issue pertaining to according prosecution sanction in case of the two other main accused were entirely ignored in case of the petitioner,
What is
thereby
the-
vitiating the entire.
That's right, we have seen that. What is the stage of trial
That
of the officer?
that is stayed in a criminal criminal petition, my lord.
Yes.
The trial has been stayed. Otherwise,
The trial has been stayed.
my lord, that is in a separate proceeding.
Then why? We would
Here,
like-
my lord, the very prosecution sanction order.
That's true. We understand you're challenging the very grant of sanction against him and not against others who too were equally responsible if at all the offense would be proved.
And in fact, the ground, if your lordship compares the two orders, the order where,
But Mr. Indranil, you know the law that this parity is not applicable in cases of grant of sanction
It is-
or criminal prosecution. It all depends. So we will see why your trial has been stayed.
that is on a,
We would like to have that order first.
uh,
Then why do we take any decision here?
at page one
I think
seventy-seven.
one of the grounds for a stay of trial would have been this only. That sanction has been challenged, sanction is defective,
No, I don't think so.
but I think this has to go to the trial court to look at it at the time when it is necessary, otherwise not. That's what the latest law is.
I appreciate that. Our grounds were,
Mr. Indranil Chaudhary, the better option would be to have an adjournment or to have it fixed when the trial commences. Or sometimes later, or you bring on affidavit the order passed by any judicial authority, whichever court, that your trial has been stayed.
that is there at
Then-
page 178.
Page
178.
117.
177 it starts. 177.
2015.
And this is nothing. It can't remain state. Who appears for the other side? You appear for whom?
Respondents 1, 2, and 3.
Respond number 1, 2, and 3 are whom?
Who
Who are the respondents?
Chief Secretary, the personnel, the secretary
What
personnel.
have you done for lifting the stay? This is an order of 2015.
Yes, my lord. That
Which application have you filed? Why then we should not stay the grant of sanction?
the only thing, if I may most humbly submit.
I think you have
as a
followed the
qual-
question of the court. If we are so much interested in prosecuting him, then perhaps you should have taken some proactive steps of having this stay lifted, no? 12/3/2015, 10 years have passed by.
Well, the only thing, my lord, as far as my learned senior colleague's submission is concerned,
Chaudhary, the better option would be that we dispose of this petition saying that this shall be considered at the time of trial.
yes, my lord, that's
And that remains, under animated suspension. They have to take steps, no? That's a better way. Let's see the
so
improved
prosecution
judgment.
sanction
But,
exists, my lord, it has
if your
to go
lordship
to
will
the
kindly,
learned
in
trial
fact,
court, my lord.
in fact, my lord, I was reading para 4. The rest of the contentions are recorded there itself, my lord. 4 or 5 considerations. May I read that para 4 from where I left? He further submits that the 3 charge sheets in in respect of the petitioner and the other 2 said co-accused persons indicates that they were identically worded except for a few facts and figures. However, though prosecution sanction in respect of the other 2 persons were declined, prosecution sanction in respect of the petitioner was granted. He further submits that the protection granted under guaranteed under Article 14 of the Constitution of India has been violated with all impunity, particularly since various relevant considerations in the case of the petitioner, such as the brief tenure in the post of in charge BDO as additional charge having been made to serve against his will, primary responsibility of the principal secretary and project director for implementation of NREGA, assets and liabilities not being proportionate to known source of income. And most importantly, the opinion of the learned Advocate General, Assam, were entirely ignored. He accordingly submits that the hostile discrimination has been meted out to the petitioner. He further submits that the affidavit in opposition filed by the state respondents, there is no explanation whatsoever as to why germane and relevant considerations were ignored in case of the petitioner.
Heard Mr. Chaudhary, heard Mr. Indra Chaudhary for the senior advocate for the petition, for the appellant, and Ms. Sunita Sharma, government advocate, state of Assam. The challenge in the present appeal is to the judgment of the learned single judge, whereby the prayer made on behalf of the appellant / writ petitioner, setting aside the order of sanction against him, has been rejected. The short facts necessary for disposal of this case are that the appellant, an officer of the Assam Civil Service, was subjected to a criminal proceeding the case against him was transferred later to CBI. The appellant was later charge sheeted along with many others. However, since the misdemeanor was, the sanctioning authority denied sanction to the other accused persons similarly situated or having graver charges against them. But sanction was granted against the appellant. The contention raised on behalf of the appellant here is that the learned single judge did not take into account some necessary facts before denying his prayer. The appellant was entrusted with an additional responsibility of in-charge block development officer at Deung Valley Development Block, Maibang. He had been writing to the government for relieving him of this additional responsibility, but to no avail. It was only later that the FIR was lodged against him, which was transferred to the CBI for investigation. The allegations against him were primarily directed, the lapses for which the criminal prosecution was launched was in fact the prime responsibility of the project director and the principal secretary for MNREGA implementation. The further submission is that there was no evidence of any disproportionate asset of the appellant. The Advocate General of Assam, who was consulted, had also opined in favor of the appellant. Thus, the contention of the appellant here is that he was discriminated and was put to a selective prosecution where two similarly situated officers were spared despite they carrying similar charges against them. A question therefore was raised whether decision-making process for granting prosecution sanction stood vitiated because of non-application of mind and failure to consider relevant facts and circumstances in favor of the appellant. The review of the sanction order could be done only to a limited extent, but limited extent. However, it is tried that such issue be raised only before the trial court. On inquiry, it was found that the trial against the appellant has been stayed and remains under such suspension since 2015. No effort has been made by the prosecution / state to have the stay over the prosecution lifted. Stop. It would only be appropriate for the respondents to proceed in the matter so that the case reaches its finality. For the present, we only deem it appropriate to dispose of this appeal with an observation that all issues raised herein shall be considered before the trial court if such issues are raised there. The appeal stands disposed of accordingly.
Obliged.
Supplementary list for orders item 26.
I'm sorry to interrupt, madam. So far as the other matter is concerned, that TET matter, we have already submitted the written note.
That's right. All other parties also have submitted? Mr. Chaudhary?
Yeah, I'll be doing tomorrow, my lord.
Okay, Friday was the last.
Friday was the deadline.
That's right. He's early.
But even my part is also over, some correction.
All right. Yes.
May it please the lordship. My lord, the honorable tribunal has proceeded on the basis that in all situation, because of by application of the principle of standard of proof, my lord, it is not permissible. Lordship, our contention is, since both the proceedings are grounded on the same facts and same set of charges and
Mr. Chaudhary, you would send your junior to have a withdrawal order or dismissal order straight away. This was argued on the first day when I resumed.
No, Lord, I'll rely on true judgment of the Supreme.
No judgment, Mr. Chaudhary, you are aware of that. Yes, Rajya is long forgotten, and the line of decisions say that these are two separate matters.
Yes. So, my lord, in Lakshmana, there's a judgment called JM Tang. It's a case from Gujarat, my lord, where what happened?
GM Tong.
GM Tong.
I know.
Yes.
Let's have it. We'll have it.
Yes. My lord, 2006 5 SCC 446.
We are in 2025.
True, my lord, but
much water has flown through the Brahmaputra.
No, my lord, it all started with Kusheshwar Dubey,
and
where for the first time Supreme Court tried to bring in this distinction, and they crystallized in Paul Anthony. And here is a case, my lord. Here the disciplinary proceeding was over. He was punished. Then because he got a acquittal in the criminal case, and because it was based on the same set of charges and same set of witness, this honorable court said it will be. Please come to para 30, my lord. At page 460.
Yes.
The judgments relied on by the learned counsel appearing for the respondents are distinguishable on facts and on law. In this case, the departmental proceeding and criminal case are based on identical and similar set of facts, and charge in a departmental case against the appellant and the charge before the criminal court are one and the same. It is true that the nature of proceedings in departmental proceeding and in the criminal case is grave. The nature of the case launched against the appellant on the basis of evidence and materials collected against him during inquiry and investigation and as reflected in charge sheet, factors mentioned are one and the same. In other words, charges, evidence, witness, and circumstances are one and the same. In the present case, criminal and departmental proceedings have already noticed or granted on the same set of facts, namely raid conducted at the appellant's residence, recovery of articles therefrom. The investigating officer, V.V. Raval, and other departmental witnesses were the only witnesses examined by the inquiry officer who, by relying upon their statement, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, and criminal court on examination came to the conclusion that prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt and acquitted the appellant by judicial pronouncement with the finding that charge has not been proved. Now, this is important. It is also to be noticed that the judicial pronouncement was made after a regular trial and on hot contest. Under these circumstances, it would be unjust, unfair, and rather oppressive to allow the findings recorded in departmental proceedings to stand. In fact, here, my lord, the DP was over. I can demonstrate, my lord, same charge in both the cases, same set of witnesses. So this aspect of the matter was not even gone into by the tribunal.
What happened in the criminal case?
I think the criminal case has been stayed in an
100.
at page number
119.
119, my lord, and not my instance, na? My instance. My lord, not at my instance, at the instance of one of the co-accused. 118. My lord, I may show the charges in both the cases and the list of witnesses in both the proceedings. It's not that there cannot be simultaneous proceedings. That is not my submission either.
No, that cannot be.
But this is the only exception.
Yes.
I think if your lordship permit me to place that Paul Anthony's one paragraph, perhaps at 99 to the option. $90.
Right.
Yes. Was substantially different.
Para 35, my lord, at page 695. Since the facts and evidence in both the proceedings, namely departmental proceeding and criminal case, were same without there being any iota of difference, the distinction which is usually drawn as between the departmental proceeding and criminal case on the basis of the approach would not be applicable to the instant case.
Now, what is the rationale behind this? The rationale is that,
Rationale is, my lord,
that anything said in criminal proceeding
it will
should not,
prejudice me in my,
no, the criminal trial has been stayed.
no, my lord.
Why Paul
No,
Anthony?
my lord, at my stage,
Yes.
GM Tank was a case which much ahead. In my case,
I think
the appropriate proposition should be, my lord, when it is, then DP should be stayed. I don't say, my lord,
So the-
DP should
so-
not be proceeded with.
so therefore, that's all right.
Yes.
That's the prayer which
Yes.
is
Yes.
easily granted.
Yes.
But here your trial has been stayed. Why we stay the departmental proceeding?
Oh, my lord, whether the trial has been stayed, would that be a relevant consideration? Subject to what your lordship may say, my lord.
No, that
But what
may
I'm
not have
trying-
been a
What I was
You
trying
can't-
to,
Mr. Chaudhary, you can't apply that theory of Mohinder Singh Gill is not applicable
no,
here.
Mohinder Singh not.
Mohinder Singh Gill is not applicable here.
Yes.
Therefore, the whole purpose gets defeated. That is stayed, I don't know for what reason, from
No,
2015.
my lord.
No, from 2024.
No, my lord, stay will not wipe out the trial, my lord. Stay only
will not.
gives the proceedings.
So therefore, in the meantime, the departmental proceeding can continue. This would not have any effect on the
And
trial.
then, my
Because
lord,
trial evidence has
Then, my
been
lord,
conducted.
then let us apply GM Tank, my lord, supposing in the DP I am, my lord, found guilty. In the criminal trial, I am
Charges
acquitted.
are very grave. These are not the exact charges in the FIR.
Same, my lord. If you'll also kindly permit me, please come to page 62, the charge. Page 62. The basic allegation is demanding illegal gratification. That on 12/6/22, this so-and-so case was registered on the basis of a reliable source information under section so-and-so against Deepak Das, accounts officer. Serial number 2 is the petitioner before lordships, Manoj Kumar, junior accounts officer, NHI region Guwahati, etc., etc., etc. Then my lord will kindly come to the few lines later. And with the allegation that some of the officers of NHI posted in northeastern states are indulging in corrupt and illegal activities in the matter of awarding contracts, processing and clearance of bills in lieu of huge bribes in connivance with the private contractor, such as so-and-so, so-and-so, so-and-so. Now please come to the charge sheet, my lord, in the DP at page number 99. Manoj Kumar, the then junior accounts officer, redesignated as so-and-so, while posted at the regional office Guwahati, NHI India 22, in connivance with his senior Deepak Das, demanded illegal gratification of 0.6 lakhs, etc., etc. This is one. So these are the charges, my lord, in the DP also. And as far as the list of witnesses are concerned, in the DP, which your lordships will find at page number 152. And these are all witnesses in the criminal case also.
Heard Mr. N. Chaudhary lend senior advocate for the petitioner and Mrs. R. Bora for the respondent. The petitioner had approached the cat seeking quashing of the memorandum of charge served on him. Memorandum of charge dated 25/6/2024 served on him. And all consequent orders on the ground that the charges in the departmental proceeding were exactly similar to the criminal charge against him in the FIR. Such a prayer was rejected by the CAT, against which the petitioner has approached this court. The petitioner was arrested for demanding and accepting bribe for passing bills and release of bank guarantee in respect of work awarded to the firm by NHAI, especially MSGR Infra Projects Limited. The petitioner had been charge sheeted. He was also proceeded departmentally and was served the memorandum of charge referred to above under Rule 14 of the CCS bracket CCA Rules 1965 for initiating a major penalty proceeding containing in 3 articles of charges. Which primarily revolve around the petitioner having demanded illegal gratification of 6 lakhs for himself and another from the contractor for releasing the bank guarantee of the contractor, which amounted to rupees 2.58 crores. The contention of the petitioner before the CAT was that since the departmental proceeding and the criminal case stemmed from the same event of the petitioner having demanded and accepted the bribe amount while in service, both proceedings could not have been continued simultaneously. The CAT, after having gone through the entire records, concluded that the charges in departmental proceedings and the criminal proceedings were different. The charges framed against the applicant in the department, against the petitioner in the departmental proceeding pertain to misconduct committed by the applicant, constituting violations of 3(1), then again Roman 1, 313, 314, 316, 318, 319, 3(1), then 18, 3119, and 3121 of the Central Civil Services Conduct Rules 1964. The charges framed in the criminal proceedings related to offences under sections 120B of the IPC, read with sections 7, 8, 9, 10, and 12 of the Prevention of Corruption Act. Apart from that, it was held by the CAT that quashing the departmental proceeding against the petitioner would be akin to killing a stillborn child. The proposition of law advanced on behalf of the petitioner before the CAT were repelled on the ground that at best, the petitioner could have prayed for stopping the stopping the departmental proceeding for a while till criminal prosecution was concluded. However, from the pleadings, it appears that the criminal case against the petitioner has been stayed. In that view of the matter, it would not be appropriate to pass any order in favor of the petitioner for the reason that during the period that the trial has remained, during the period that the trial remains stayed by a judicial order, the departmental proceeding could be concluded. The CAT also directed for concluding the departmental proceeding expeditiously. Even otherwise, the charges, though stemming out of the same act of the petitioner in demanding and accepting bribe money, were not exactly identical because the criminal charge related to conspiracy, as also the offense of accepting money as bribe for doing an official work. Whereas the departmental proceeding charge, whereas the charge framed in the departmental proceeding was with respect to the misconduct, there would be a subtle distinction between the two, and both cannot be treated to be synonymous under any count. In Captain Paul Anthony versus Bharat Gold Mines Limited, 1999. 3 SCC 679. While dealing with the issue, the Supreme Court held that departmental proceeding can be resumed and proceeded even when they may have been stayed earlier in cases where the criminal trial does not make any headway. In state of Rajasthan versus BK Meena, 1996, 6 SCC 417, the Supreme Court had reiterated that there is no legal bar for both proceedings to go on simultaneously unless there is a likelihood of the employee suffering prejudice in the criminal trial. What is significant is that the likelihood of prejudice itself is hedged by providing that not only should the charge be grave, but even the case must involve complicated questions of law and fact. The Supreme Court in Stanzen Toyotetsu India Private Limited versus Girish V and others, 2014, 3 SCC 636. Note of the development in the position of law. And concluded that at best, the departmental proceeding could be stayed till the conclusion of the trial. In the present case, the trial of the appellant, the trial of the petitioner has been stayed and no effort appears to be made, and no appears to have been made by the respondent to have the stay vacated. First up, in any view of the matter, considering the fact that though charges may apparently look to be the same, but they have different connotations, and that the trial against the petitioner has been stayed, we do not find any reason whatsoever to interfere with the judgment of the cat. Finding no merit in this petition, we dismiss.
Next. Yeah.
Daily list for hearing, item 3.
Lord,
Yes, Mr.
this is a matter,
Ji.
the learned single judge, my lord, directed an inquiry. And during the inquiry, my lord, whatever we contended before the learned single judge, everything has come to light. Now, what the government itself has done, my lord.
Some facts would be required, Mr.
Yes.
Chaudhary.
Yes.
You know what has happened?
Yes. My lord, a contract was awarded to the appellant, my lord, a road construction contract.
For construction of a road.
Road.
Yes.
Midway, my lord, on the ground that there was delay in execution of the work, my lord, my work order was terminated.
Okay.
Following termination, my lord, by so-called advertisement, again, a retender was issued. And in
For
that,
the remaining work.
yeah, for the remaining work, and in that retender, my lord, respondent number 6 was awarded the contract. Within 2 days, my lord.
Who appears for respondent number 6?
I'm appearing for the respondent number 6, my lords. All. My lords, may I make a prayer, my lords? My lords, yesterday an affidavit has been filed, bringing in certain new facts. I need some time to seek instructions, my lords. Can it be taken up next week, my lords? 2 letters have been annexed in that. One of the letters.
What affidavit have you filed, Mr. Chaudhary?
Nothing, my lord. The government has proposed some action. That is what we have brought on record. Actually, what our
has
stand stands vindicated by the stand of the government.
Government has proposed what action?
Yes, that is, my lord, we have filed an affidavit at page 804. Page is number 4.
The balance also appears to be completed.
What was not given by the learned single judge now has been given by the government itself.
What is it?
Please come to page 805, my lord.
305.
805.
Why has it become so bulky?
My lord, there are so many reports and all. My lord.
Would that be necessary for deciding whether termination was bad, whether retender was justified? 805.
Yes. Considering the above, I am directed to request you to kindly take the following action. Take action.
Yes.
My lord, after noticing the previous facts, if the lordship may kindly come to 804, my lord.
Yes.
What were the illegalities that has been noticed in the last part? Illegal cancellation of original contract, improper billing and measurement, dubious estimate documentation, non-transparent NIT process, forced tender comparative statement, suspicious payment timeline, work execution proceeding allotment. So under these different 7 heads, my lord.
And who is writing this letter to?
It is by the, my lord, government, my lord, in the Public Works
The chief
Department.
engineer is writing this. No.
He is writing to the chief engineer because learned single judge has directed an inquiry, my lord, by the order and the chairman.
The inquiry.
Yes.
The deputy secretary to the government. Yes.
Now, aforesaid facts suggest that the entire reallotment process was marred by forgery, cheating, and gross procedural violation. The original contract was never legally terminated. Payments were made to the new contractor on the basis of forged documents, resulting in loss to the public exchequer. delay in execution.
That's all right, but Mr. Chaudhary, would
Yeah.
you be interested in taking over the work?
Yes, yes,
No,
very
no,
much.
that work also, the retendered work also has been completed.
Yes, no, my lord, they haven't done anything because they worked only for 2 days and they wanted to take a 1.91
And
crore.
perhaps
There is
some-
a restraint order. Partly the money could have been taken, partly could not be taken. Or 1.91. In fact, that is one of the recommendation of the committees that, my lord.
Let's see the impugned judgment.
Yes. I do. No problem. So lordship would kindly come to page number 448, my lord.
If you could give
Internal
us-
page 19 of the judgment.
Yes.
Lordship will kindly permit me to read from page number 448, para 12. Previous page,
Page,
internal 18.
yes,
Further, towards the bottom, para 12.
Yes.
Further, after termination of the original contract, the superintending engineer Kachar asked the executive engineer, Hailakandi Dispatchal Division, Hailakandi, to inspect the work, and accordingly he inspected the site on 9/1/21 and submitted a report of details of the work executed by the contractor, Sri Mansoor Ahmed, that is the appellant, and the details of the work executed by Gulzar Hussain Chaudhary, balance work. In this inspection report, it is clearly mentioned that the contract for balance work, Sri Gulzar Hussain Chaudhary had executed some quantities of work till inspection date as engaged by the executive engineer after withdrawal of work from the original contractor. The entire work of PMGSY package has been completed on 26/5/21 and running bill for the balance work amounting to so and so was prepared and has been paid with necessary deduction to contractor Gulzar Hussain Chaudhary till date. Though the work has been completed, final bill has not been prepared and payment could not be made as the Honorable Guwahati High Court has allowed payment of 50% of the balance work value till disposal of the matter. Completion details are available in so and so. Since public money is involved, the finding arrived at by the additional chief engineer's report are required to be
that's all
followed up
right,
scrupulously.
but this is additional.
Yes,
This is a side street.
yes, yes.
Because public money was involved.
Yes.
Now, this inquiry, this ordering of inquiry was against respondent number 6.
6, 5 and
That
6.
has come.
Ah.
But so far as your termination of contract is concerned,
Yes.
the court was very specific that it is not liable to be interfered with.
That's why we were before our lordships. Now the finding is that termination was wrong by the authority themselves. That's why I say, my lord, our stand stands vindicated.
We can consider, we can relegate you to the concerned department, PWD, to consider.
Yes,
whether
in terms of
balance-
that report, that's all.
But then we'll have to allow him to, because this is
Yes,
against him.
certainly. Only thing
Yes,
is, that-
Mr. Respondent number 6.
This
You need
inquiry
to
report,
respond to this.
yes, I need
Because
to,
yours would be foreclosed. You will not get any payment now with this report. So
that's
what
why I
can
was
you
taking
say
some
to say
time.
this?
I need to respond to this. The inquiry report, a letter has been annexed, addressed to me. An
Take
inquiry report,
What's your name?
S. Vishwakarma. S. Vishwakarma.
During the course of arguments, Mr. S. Vishwakarma, learned advocate for respondent number 6, submitted that the latest affidavit filed on record, brought on record by the appellant would require to be responded as it is the result of the inquiry report initiated pursuant to the impugned judgment, in which it was found that the termination of contract of the appellant was bad, and equally wrong was retendering of the work. The report also includes charges that the respondent number 6 did not do anything substantive, but received payments which amounts to swindling of government funds. Mr. Vishkarma therefore submits that he would be required to respond to such affidavit, or else all his rights would stand foreclosed. Acceding to his request, the matter is adjourned to. We give you 2 weeks. Let's be done with it. 2 weeks, re-notify on so and so date. So the rejoinder affidavit must be filed. The reply affidavit must be filed positively on or before the next date.
Date to date.
14/8.
And my lord, may I pray for one thing? Let government also take the instruction what they propose to do based on the report of the government, my lord. Because
We will relegate it to the government now.
and eventually that only can happen.
We'll
Yes.
dispose of the appeal, send you there, you
Yes,
apply. If
yes.
they find that you are
In the
a
meantime, my lord,
viable contractor and you can complete, they will give work to
and in the meantime, my lord, the executive engineer in the departmental proceeding, he has been imposed a major penalty.
All right.
All his pensionary benefits
everything
and all.
against you, Mr. Vishkarma. And we'll be forced to, we would be, I mean, we don't know what decision we'll take on the next day. We'll be forced to tell the government that necessary action should be taken against you. Recovery of money as well. Therefore, you need to respond.
I will come up.
Surely.
Deeply obliged.
Item number 5.
Schedule 6 to the Constitution.
May it please your lordship.
Yes.
Well, this matter pertains to challenging the various of Karbi-Anglong Autonomous Council, Land Revenue Act 1953,
Yes.
and the Fourth Amendment Act of 1973.
Yes.
My lord will appreciate this. I would like to take up the brief facts, how we approach this honorable court in this present matter. What happened was that the petitioners who were residing in a plot of land in the Karbi-Anglong area, in the block of Lahorijan, they were issued with one eviction notices of under 18.2 and 18.3 of Assam Land Revenue Regulations 1886, challenging that these notices were issued without following the due process. We approached this honorable court. The matter was registered as WPC 7211. Now, in that matter, after hearing for 2 consecutive days, the interim order was being granted. The lordship will kindly take the
The
dates.
eviction notice was stayed.
Yes, my lord. Eviction notices were stayed. Now, when the eviction notices were stayed, we filed an additional affidavit. Additional affidavit raising certain legal issues. Our issues was that the land belonging to an autonomous council, land situated in an autonomous council, does not come under the jurisdiction of council as a whole, is the owner of the land. It belongs to the state of Assam. Why we have said that is that, if your lordship will appreciate, under the Government of India Act 1935, when the rulers were there, some portions of lands were being under the sovereign. Now, when India got independence, by virtue of 2 articles, it came before the state and the center. Now, as far as autonomous council are also concerned, it went to the state.
Yes.
Now, 6th schedule was there brought in for the object that the upliftment of those people in that area.
That's right. That's right.
Now, this issue has been raised in 2 occasions. One was in Meghalaya, where the Honorable Apex Court, it was a judgment passed by this Honorable Court. Then leave was granted, was raised, matter was taken up to the Supreme Court. The 5 judges have said that yes, land belonging to a council, of course they can take revenue, royalty and all, but they cannot alienate the land. They cannot transfer the land. So the ownership of land has to be with the state. That is a settled decision. It was in 1976. Subsequently, there were 2 judgments passed by this honorable court, division bench, Dharanikanta Das and Udal Das Panikar, same issue with the same council that yes, land belongs to Assam. Now, what here in this matter was that they are saying in the affidavit that they have brought this legislation to legislation by exercising the power under this 3(1)(a) of the 6th schedule. That is alienation of land. My lord can kindly come to the constitution once. 3(1)(a). Sixth schedule, my lord.
Yes.
Powers of the district councils and regional councils to make law.
Yes.
Kindly come to A. The allotment, occupation, or use, or the setting apart of land other than any land which is a reserved forest for the purpose of agriculture or grazing, or for residential or other non-agricultural purposes, or for any other purpose likely to promote the interest of the inhabitants of any village or town, provided that nothing in such law shall prevent the compulsory acquisition by any land, whether occupied or unoccupied, for public purposes by the government of the state concerned.
Just give 1 minute to us.
Yes. Now, the lordship will have given the 2 acts. Kindly.
No, you're referring to
3(1)(a), 3(1)(a), 3(1)(a).
3(1)(a).
Now, your lordship will kindly come. There is a judgment of the Honorable Apex Court, which I was referring. It is District Council of United Khasi, 1971, 3 SCC.
You've got the photocopy?
I have given the copy, my lord. Page 708. My lord is there?
Yes.
Kindly come to para 4.
Yes.
The narrow question posed in the present controversy is whether para 3(1)(a) of the 6th schedule confers on the district council power to make laws with respect to transfer of land. In other words, whether the subject of transfer of land is covered by the expression allotment, occupation, or use, or the setting apart of land.
Yes.
The High Court held that para 3(1)(a) of the 6th schedule does not empower the district council to legislate with respect to transfer of land. According to that court, the expression the allotment, occupation for use, or the setting apart of land does not take within its fold transfer of land. On the plain reading of para 3(1)(a), that is, kindly come to para 12.
Yes.
On the plain reading of para 3(1)(a) of the 6th schedule and of the preamble and section 3 of the Impugned Act, the first prima facie difficulty which one faces in accepting the appellant's argument is created by the departure by the district council from the language used in para 3(1)(a) of the schedule in the language used in the preamble and section 3 of the Impugned Act. The addition in the preamble of the word transfer to the word allotment, occupation, or use of land used in para 3(1)(a) of the schedule is indicative of an intent to enlarge the scope of the object and purpose of enacting the Impugned Act beyond the limits of the power conferred by the Constitution. And then in section 3 of the Impugned Act, we find that a completely different phraseology has been employed for prohibiting various kinds of transfers in express terms. This leaves no doubt about the great importance attached by the district council to the addition of the word transfer in the preamble to the expression actually used in the 6th schedule for conferring legislative power on the district council. No convincing explanation has been offered for this departure from the language used in the constitution from which alone the district councils draws its power to make laws. If, as is forcefully contended on behalf of the appellant, the words used in para 31A of the 6th schedule are comprehensive enough to include within their swift transfer of land, then it is not understood where was the necessity of adding the word transfer in the preamble and use a wholly different phraseology in section 3 of the Impugn Act. The lawmaker, it may be pointed out, may well be presumed ordinarily not to waste words by adding them as mere surpluses. Kindly come to para 16. My lord is there?
Just a minute. What was under challenge? United Khasi Jaintia Hills District Transfer of Land Act.
Yes, my lord. It is clear, para 16, my lord. It is clear from this provision read with para 31A already reproduced that the district councils, unlike the parliament and the state legislature, are not intended to be clothed with plenary power of legislation. Their power to make laws is expressly limited by the provision of the 6th schedule, which has created them, and they can do nothing beyond the limits which circumscribe their power. It is beyond the domain of the courts to enlarge constructively their power to make laws. Now, keeping this thing in mind,
Para 17 also.
my lord, the provision to para 31A merely serves to ensure that no law made by the regional and district councils with respect to allotment, occupation, or use or setting apart of land, as mentioned in the clause, shall have the effect of preventing compulsory acquisition of land for public purposes. By the Constitution, by the Government of Assam, in accordance with the law in force authorizing such acquisition. This provision by no means enlarges the scope of the power conferred by the regional and district council by clause A, and indeed, it has not been so claimed by the learned Attorney General. A proviso may undoubtedly be sometimes inserted to allay fears considered by some to be unfounded. But the question must ultimately come back to the point whether or not power to make laws conferred by clause A include the power to do so with respect to transfer of land, and this must turn upon the exact language and its primary meaning. The simple words used in clause A are incapable of bearing the construction suggested by the learned Attorney General, and the provisions found in the proviso does not in any way affect the operative effect of this clause. Your Lordship,
Just
You are agreed with the eviction notice, what?
my lord, we are agreed with the eviction notices.
That's all correct. It's getting the big transfer for thanking that one. No. It's told or years for the one thing. It's only within the past majority with respect to allotment, occupation, or use, or by or the setting apart of other than any setting apart. Or setting other this is alienation.
Whether he has got a right to be in the land. It might not be applicable. Might not be applicable.
Yes,
My lord. What your lordships, as far as para 17 is concerned, of course, the government of Assam can acquire a land, or the particular state can acquire a land for their own purposes. Now, your lordship, keeping this judgment in our mind, if we see the two acts which I have given your lordship,
no, where is the answer to this question? What does word setting apart of land mean?
your lordship, that has been further discussed, is that as far as land is concerned in the council, that is 6 schedule area, you can use that land, you can settle that land in the council itself for their own development. But you cannot transfer the land. From one person to another, you cannot transfer the land. They have to make law with respect to that. Now what happened is that they made a law under the Mikir Hill Land and Revenue Act, 1953, which I've given your lordship. Kindly see the preamble.
Yes.
Whereas it is expedient to provide for the recognition of rights over land, settlement and assessments of land and for other ancillary matters in the Mikir Hills Autonomous District. And whereas under clause A of subpara 1 of para 3 of the 6th schedule to the Constitution of India, the district council of an autonomous district is empowered to make laws with respect to the allotment, occupation, setting apart of land other than any land which is a reserved forest for the purpose of agriculture or grazing or for residential or other non-agricultural purposes, or for any other purpose likely to promote the interest of the inhabitants of any village or town. And whereas under subpara 1 of para 8 of the said schedule to the Constitution of India, it is further empowered to assess and collect revenue in respect of all lands within the district in accordance with the principles for the time being followed by the government of Assam in assessing lands for the purpose of land revenue in the state of Assam generally. Now, therefore, in exercise of the said power and all other powers enabled in that behalf, the District Council of the Mikir Hill Autonomous District is pleased to enact, and it is hereby enacted as follows. This may be called the Mikir Hill. It extends to the Mikir Hill Autonomous Council District. It shall come into force at once. Now, section 2. The Assam Land and Revenue Regulation 1886 shall apply to the Mikir Hill Autonomous District, subject to any amendments to which it is subjected for the time being in other areas of the state of Assam, and so far as it is applicable to the state in the state district, provided that all references therein to the state government and the deputy commissioner shall be read as referring to the district council of the Mikir Hills Autonomous District and the revenue officer respectively. Now, by doing that, they brought the entire Assam Land Revenue Regulation 1886 in their gamut, where it includes even transfer of land, ejectment of land, which they are not supposed to, as per the judgment of Honorable Supreme Court. Yes, I must admit, there was an amendment, Constitution Amendment in the year 1995, where your lordship will find in the para 6 schedule, para 3, there was a subsequent para was added, para 3A, where the clause O was inserted, where it talks about alienation of land. My lord is there?
I am at para 3 of the 6th schedule.
6th schedule, your lordship, it is an amended provision, it has been brought. Oh, my lord is there? After paragraph 3, it starts with after paragraph 3, the following paragraph has been inserted in its application to the state of Assam by the 6th schedule to the Constitution Act, Amendment Act 1995, Section 2(3). 3A, additional powers of the North Kachar Hill Autonomous Council and the Karbi Anglong Autonomous Council to make law. Now kindly see O, alienation of land.
Yes.
So now, after this amendment,
Just give us a minute. Alienation of land, yes.
Yes.
Hmm.
Now,
Hmm.
to I may be wrong, but I am of the view that after this amendment, constitution amendment, if the council would have brought a fourth amendment, or if they would have enacted a law in concern with land, then I don't have a case. I would not have a case. But there in the affidavit also they are saying that they have enacted this two piece of legislation by exercising the power under 3(1)(a), which does not give the power to them to exercise the power which a state will be exercising under entry 18.
This amendment came when?
Which one, my lord?
This
1995.
And this is the law made in 1953.
1953.
Yes.
And they have accepted in the affidavit. The respondent have accepted that yes, the power of taking over land, transferring of the land, they are doing it under 3(1)(a). At that point of time, 3(1)(a) does not give the power which they are claiming they can exercise. That is the main issue in this matter.
The issue is thus, as you said, is relegated to the background. Now, we had not seen 3(a). This comes only later.
My lord.
The law was made. Now, with respect to law, what is the the rule of retrospectivity so far as the law is concerned?
My lord, with my
They would only be required to make necessary amendments in the act.
yes, my lord.
That can be done.
But they have not done it till now.
They will do it, but that would not justify or bolster up your case. Now, this is with respect to alienation of land also. And we had certain reservations otherwise also, because by this land, application of Assam Land and Revenue Regulation, the entire gamut of regulation under 1886 would not only be limited to alienation. So this can always be brought into the statute. It could be made applicable minus what is not permitted under 3(1)(a).
My lord, that is one aspect which your lordship kindly come to two judgments of the division bench. What this honorable our division bench has said. That is one Tarani Kanta Das, your lordship, given.
Yes.
Para 7, my lord. Here issue was with respect to mortgage and PICAs. Mortgage and PICAs, which they brought it under Transfer of Property Act. Whether the council has power to make laws. Now, kindly come to para 7. A division bench of this court in AI 1960 Assam.
Well, that's what I said, no?
Yes.
The transfer of land could not have been effected under the act.
My lord.
But so far as things which were different from transfer of land or alienation of land, but governed under the 1886 rules of, revenue regulation of Assam.
My lord.
Where was the problem? There could be no question of not incorporating it, except for these things. Now, so far as the powers to the council is concerned, the regulation of 1886, to that extent, would be applicable. Why do they have to make law with respect to other things, which is not prohibited?
My lord,
suppose you have understood what I am saying.
I understood, my lord.
Merely because, all right, pursuant to this regulation, they have issued the eviction notice which has been stated. That's all right.
My lord.
Eviction for what?
Eviction for my land.
No, but who are you for the purposes
My
of
lord, we have been staying in there. We have been staying in that those parcels of land because, your lordship, that area where we are residing, it's a bordering area with two states, that Assam and Nagaland. And predominantly that in that area, all the people are of the tribal origin. Be it the Karbis, be it the Nagas, they're all residing. In that context, they have been staying for a long period.
Let's see one of the eviction notices.
My lord, that is your lordship will find page 236.
Would it come under the proviso?
No.
Why?
Your lordship will kindly see the,
Provided that nothing in this, in such laws shall prevent the compulsory acquisition of any property, whether occupied or unoccupied, for public purposes by the government of the state concerned in accordance with the law for the time being enforced. Let's see the eviction notice.
my lord, 236. It is series, my lord, annexure 69.
Yes.
As per the deputy collector's report, it is learned that you have occupied the government land illegally and without permission, which is scheduled in the backside of this space. Hence, you are hereby directed to remove the house, walls, and crops from the aforesaid land within 15 days of receipt of the notice, failing of which you will be forcibly evicted from the land and also to be liable to be fined.
This is no transfer. This is no transfer.
My lord, what I wanted to demonstrate is that
Therefore, is there any provision for settling the dispute? Now, that's a government land.
the government is claiming.
So therefore, this will not be uncovered field. This will not be an uncovered field. They have to retain that land, no?
No, your lordship, the question was there in 7211, the earlier writ where eviction.
You are making your rights synonymous with the rights of the council.
What I am trying to impress is that the eviction notices which have been issued.
No. There must be some authority there for you to settle that this is not the government land.
No, that issue that was been directed by the honorable court, land single judge, that you go and give the representative to the deputy commissioner.
Yes.
DC, we gave it, but DC did not.
But then this eviction notice pursuant to the incorporation of the rules of 1886 into the act would not be violative of this. I mean, especially minus that extent, to that extent. Now, what judgment Tarni Das you have shown and the other judgment of Supreme Court, that does not cover this field.
Your lordship, in Upananda Panikya Das, that third case, there also the same issue was raised.
This issue does not concern us now with respect to this eviction notice.
My lord, your lordship will kindly see.
Just a minute. This is neither transfer nor settlement nor setting apart. This is nothing. This is only restoring the land of the government.
Your lordship, the government is.
You're confusing this list, and therefore it was all state.
My lord, your lordship, no. It was staying in a different context, my lord.
No.
The stay was in a different
Power
context.
to the council under the constitution was for the development of the area. Therefore, they were permitted to make laws with respect to land. Exact phraseology has to be used for this. That's not for settlement. This is for allotment, occupation, or use or setting apart. How would the land be allotted to any person who is needy if you encroach the government land? That is a different process altogether. It doesn't come under setting apart. The eviction is absolutely different.
No, your lordship will appreciate this. The land in which I was sitting, your lordship has taken a view that this is how the stay order came. You kindly come to that order, stay order.
No, I am not taking any view. We are only thinking that this issue was unnecessarily given a flip.
Because
merely because a party received an eviction notice, that does not mean that the entire law is bad. 1953, 1956.
Even the eviction notices were not been issued as per the eviction. For example, if you take it also, it was not issued as per the law.
This is no alienation of land also.
Pardon, my lord?
This is no alienation of land also. This is just recovering the land belonging to the government.
My lord,
After all, what is the purpose of introducing 3A?
For upliftment of those people inhabitant. We are also there.
Upliftment doesn't mean the upliftment of an encroacher, that he shall be allowed to remain on that land.
For that, there has to be a finding.
So therefore, the finding, you go before the authorities, say that it is not a government land.
But they have not been doing it.
How do you question the competence of the government to work under the law and tell you that no, you must leave? That is, this notice is to you for you to claim your right.
My lord, may kindly bear with me for 1 minute. Kindly come to Upanida Das judgment. Your lordship, for a minute.
Das judgment is not going to help.
No, my lord, kindly come to this judgment.
We will. And precisely for this reason, you have challenged the very act. And you say that the application of Assam Land and Revenue Regulation 1886 is bad, because then it will bring within its fold the powers which the council does not have and which the state of Assam has. But no, it is to that extent. Look at this application. The Assam Land and Revenue Regulation 1886 shall apply to district subject to any amendments to which, sorry, provided all references therein to the state government and deputy governor. It has been left open-ended. That's the only problem.
No, your lordship will,
It has been left open-ended.
yes.
With respect to anything, with respect to, I mean, the rules of 1886 would be applicable to the extent of the power given to the district council or the autonomous district council under Schedule 6, Para 3A. That is what it means. If it doesn't mean that, we will specify.
No, your lordship will appreciate one thing. Kindly come.
And this 1953 has never been questioned.
No,
This Mikir Hills Act number
no,
1.
same. It was Mickey Hill only. It has been, now it has been saying Karbi Anglong.
That's all right.
That's all. Now your lordship will kindly see Uday Das Panikar case, my lord.
Page, paragraph,
Para 3.
Tarni Das you are referring, no?
Yes, Manida. Panikar Palat.
No. Panika.
Udal Das Panikar Prasad. Para 3. Before we proceed to consider the impugned notices, impugned notices, a point was asked before us regarding sovereign right over land in an autonomous district. That is whether land based in the state or in the district council. This point was taken up by a division bench in the Tarani versus Karjana District Council, where in Para 8 of the report, it has been held as follows. A division bench of this court in 1960 in this regard held that land comprised in autonomous district does not belong to the district council in the sense it is owned by the state of Assam and not by the district council. Though in the case there is no elaborate discussion touching the aspect of the issue, but that decision holds the field as the decision was not dissented or doubted for over a period of over 3 decades. We would therefore like to add that under the Government of India Act, the areas comprised within the autonomous district in questions were partially excluded are 3, and as such the sovereign right over land vested in the crown. After the lapse of paramountcy, such properties and assets have vested in the union and the corresponding state respectively. This position has been made clear in Article 294 and 295 of the Constitution. According to Article 162 of the Constitution, executive power of the state shall extend to the matter in respect of which the legislature of the state has power to make laws. Entry 18 of the list 2, state list of the 7th schedule to the Constitution, the land is a state subject. Therefore, the right over land based in the state. Clause Para 5. Clause A of subpara 1 of paragraph 3 of the 6th schedule to the Constitution empowers the district councils or an autonomous district to make laws with respect to allotment, occupation, or use, or the setting apart of land other than any land which is a reserved forest. My lord, which is a reserved forest for the purpose of agriculture or grazing or for residential or other non-agricultural purposes or for any other purposes likely to promote the interests of the inhabitants, village or town. This legislative power of the autonomous districts came up for consideration before the Apex Court in the District Council of United Khasi, which we have referred, my lord. And it was held that the district councils, unlike the parliament and the state legislate, are not intended to be clotted with plenary power of legislation, and their powers to make law is expressly limited by the provisions of the 6th schedule, which has created.
Mr. Counsel, your arguments initially in the first blush appeared to be attractive, but it is not impressing us for any reason. For the reason of the recognition of the fact that there is no plenary powers to the council to legislate on the subject, they say that they can make law with respect to this.
My lord.
Therefore, in order to preserve that, they have made a law with respect to suitability or whatever occupation, settlement of land, and they have incorporated this Assam regulation of 1883. So therefore, any provision in the regulation of 1883 which deals with alienation of land, they are not entitled. But so far as it relates to, settlement, so far as it relates to, preserving the land or allotment. Therefore, you tell us whether there is any provision, whether there is any conciliatory body or any mechanism whereby you prove your rights. This is a right which you can claim only under the civil courts.
But as far as this,
Where have you asked the question? Now, we will ask the state. Yes, who appears for the autonomous council?
Lordship may look into, my lord, the
No,
judgment.
before looking into all
My
this,
lord, that,
let us have.
my lord, they have.
Unnecessary
My lord, the state-
confusion only confounds the position of law,
My lord.
which is not correct.
My lord,
Now, you have issued an eviction notice to him.
my lord.
On what ground?
My lord, that notice was issued under the Rule 18 of the Settlement Rules of Assam Land and Revenue Regulation 1886. And the case is pending before the single judge. Single judge passed the order to make an inquiry. Accordingly, we have made an inquiry and found that the patta, my lord, periodic patta shown them by to us, my lord, is a forged one, my lord. So the inquiry is there. We have filed the affidavit. My lord, we have filed the affidavit before the single judge. That petition is pending since 2021.
Answer the bill, let it remain pending. He has
Pending, my lord.
questioned-
Here, my lord, they have
he
lordship.
has questioned the virus.
My lord,
That
here,
is-
my lord, here they have challenged the Land Revenue Act 1953. And the case relates to the Supreme Court regarding transfer of land from tribal to non-tribal and non-tribal to tribal. And that is the page 709, my lord. What is there? What is in that particular act, my lord? There is a provisions that I'm reading it, my lord. Page 709 of the judgment.
709 of?
1971 3 SCC, who is my learned friend referred it, my lord. There is different context, my lord. That case was, my lord, before the Supreme Court, my lord. 1971 3 SCC 708.
Yes.
My lord, para 3, my lord. As it is preamble shows that the Impugned Act was enacted because it was considered necessary to make provisions in the autonomous district of the United Khasi and Jaintia Hills with respect to the transfer, allotment, occupation of the land. Section 3, that was silenced, my lord. Section thereof the provision as follows. No land with the district council shall be sold, mortgaged, leased, bartered, gifted, or otherwise transferred by a tribal to a non-tribal, or by a non-tribal to another non-tribal, except with the previous sanction of the district council. That provision was silenced, my lord. And in this particular act, my lord, there is no such provisions. Under the Karbi Anglong Land Revenue Act 1953, there is no such provision. These provisions is there in another act, my lord, we have enacted. That is the Karbi Anglong Transfer of Land Act 1959. That was not silenced before your lordship. And my lord, provided further that sanctions shall not be accorded.
Have you put it on record that on inquiry it was found that his lands
My
are?
lord, we have filed the affidavit before the single judge in the different petition they have filed it. In this particular, they have only silenced the that we have the no legislative competence to enact the law, my lord. My lord, under the section 318, we have the competence to enact the law in respect of the allotment of land, my lord, and accordingly we have adopted it. And regarding transfer of from tribal to non-tribal, we have another act, which the petitioner has, my lord, put before your lordship the arguments, my lord. That is a different act, my lord. In that context, my lord, he has not stated anything about mention about that particular act. And regarding this act, my lord, regarding this judgment, my lord, that is regarding the transfer of land from non-tribal to tribal, my lord. That is not related to the eviction or allotment of the land, my lord. And lordship will look to Article 244, my lord. Article 244, my lord, of the Constitution. Article 244. Administration of scheduled areas and tribal areas, my lord, that is to the provisions of the sixth schedule shall apply to the administration of tribal areas in the state of Assam. So, my lord, for administration of tribal areas, my lord, sixth schedule was enacted, my lord, and that is, my lord, the power of allotment, occupation of land is there under section 31A. Subsequently, it was amended in 1995, and power of alienation of land is also there, my lord. And my lord, lordship will look at the paragraph 8 of the sixth schedule also. Paragraph 8 of the
One second, sir.
I'm referring at under my lord, Article 244 in the context that it is in the border district of my lord Nagaland and my lord Assam, my lord, and as per the Article 244, my lord, if any there is any boundary dispute is also there, then it is required to be governor is required to consider a committee, my lord. And the governor has already considered a committee also in respect of the dispute regarding the boundary zone. Paragraph 8 and paragraph 12, Lordship will look into it. Paragraph 12 and paragraph 8 and paragraph 12 of the 6th schedule, my lord.
Yes.
Well, paragraph 8, my lord, that is related to power to assess and collect land revenue and impose taxes, my lord. And the autonomous council have the power to, my lord, to assess and collect the land revenue. Accordingly, we have enacted another act for that purpose, my lord. That is the Land Reforms Act, my lord. And my lord, paragraph 12.
So has been challenged, no?
That has not been challenged. There are many acts are there, only they have challenged the Land Revenue Act. Transfer of land from tribal to non-tribal, my lord, there is another act. And regarding the land reform, there is another act. And the forest, there are various acts are there, my lord, we have enacted. The paragraph 12, my lord, Lordship will look into. Application of acts of parliament of the legislature of the state of Assam to autonomous districts and autonomous regions in the state of Assam. No act of the legislature of the state of Assam in respect of any of the matters in the paragraph specified in paragraph 3 of this schedule as matters with respect to which the district council or regional councils may make laws, and no act of the legislature of the state of Assam prohibiting or restricting or consumption of non-distilled alcoholic liquor shall apply to any autonomous district or autonomous regions.
This is not in contempt of.
Not in context, my lord, but the power, my lord, regarding the, we have the power to enact law regarding allotment, we have enacted law.
He has taken a very circuitous route. He
My lord.
says that the very 53 Act,
My lord,
act by the Autonomous Council, in which the Assam regulation of 1886 has been incorporated is bad.
adopted.
Because it provides very wide powers, and therefore this amounts to crossing over the plenary powers. Because under the garb of Assam, no, that argument
My
is
lord.
not.
And regarding transfer of land, that judgment, my lord, regarding transfer of land from the tribal to non-tribal, my lord. In that context, also Supreme Court.
That issue, he is resting before the single judge.
My-
Here
yeah,
it says
my lord, we
that
have, my lord,
only because of the incorporation of the Assam regulation
My lord,
of
for
1886.
that purpose,
He says that it cannot be.
for that purpose, we have, my lord, another act, my lord. And regarding, my lord, now the also to give the more autonomy to the autonomous council, my lord, the constitution amendment has already been placed before the parliament also. my lord.
Your
That
lordship,
is my submission.
That's right, but please give us the affidavit which you have filed in the single judge's petition.
Right.
Put it on record.
Right. That has already been filed. my lord.
You file it here, no? Give it
My
to
lord,
us.
my lord, my lord,
You don't want to file it on record, you can give it to us directly.
my lord.
your
When
lordship,
would you do it?
Well, within a week.
Yes.
Your lordship. Your lordship, a call for the record of that case also.
my
it
lord,
will
I
come
will,
on
I will request your lordship, I'm proposing, subject my friend also agrees. Your lordship may post this matter a week after, any day, next week, with a single bench matter also, because it can be decided. It can be decided.
That's better.
Otherwise, you'll again at a multiplicity of proceedings, my lord. That is WPC 7211.
WPC
7211.
pending before?
Pending before a single judge.
And the similar revision has already been.
My lord, one
disposed of,
more
my lord.
forest matter is also there. Raising
this is
this,
a different
that-
case, my
that- same in council
My lord.
only.
My lord, these are cannot be tagged, my lord. Other
No,
than that-
I'm just putting it, as you have referred forest matter.
No, I'm not referring the forest matter. I'm regarding the eviction notice only, my lord. Forest matter is a different thing.
They
National
also have-
Tribunal is also taking up the matter.
He has taken a different route, Mr. What's Mr. Huh? No, Mr.
J. Sutia.
Mr. Chutia, he has taken a different route.
My lord.
He is challenging the virus of Karbi-Anglong Land Revenue Act of 1953 and the Fourth Amendment of 1973 on a totally different ground,
My lord.
which on deeper analysis would be found to be absolutely non-existent.
My lord.
For the reason of the council not having the plenary power to legislate, they have incorporated this. Therefore, the sovereignty of the land, the sovereignty of Assam state over the land in the hill state remains intact.
My lord.
It is only with respect to the purposes for which it shall be used.
My lord. My lord.
Therefore, suppose somebody is an encroacher, he
My
has
lord.
to be removed.
My lord.
That
That is-
notice will
that
go,
is- my
that is
lord, that is
only
the point.
towards the preservation of the land.
My lord. That is only the point.
Transfer to
My lord.
non-tribal
That is not
to a
applicable
different
here, my
tribal
lord.
or this.
My lord. My lord. That is
So
the-
this eviction notice, that is pursuant to, maybe pursuant to a provision contained under Rule 18
my lord.
of the regulation 1886.
1886, my lord.
But then that does not relate to any transfer.
My lord. That
And
settlement
that is
rules,
what
my
is
lord, that is
offending
not
him.
related to
Therefore,
that.
he has taken a different course.
My lord.
In fact, it is not required to bring that matter here
My lord,
before the
my
decision bench.
My lord, at least
Yes,
if
my
your
lord.
lordship puts
If
up after a week,
That-
I will try to satisfy.
No,
No.
you have done it well, but
That-
for some time only. Do we keep it or we decide this way? No. We can adjourn for a week, but there is no need to bring in
My
that.
lord,
You
my
just give me the affidavit.
My lord, my lord.
Let it be
Keep that.
decided.
My lord,
by
if
the
your
single-
lordship decides the matter, I'm telling you, your lordship can just propose. If your lordship decides this matter, presumably against me.
The single judge would follow what we decide.
Exactly. So instead of that, because the persons who are residing in that area,
Makes sense.
my lord,
Take down. Heard Mr. S.
Borgoheim.
Learned advocate for the petitioner and Mr. Stutia for the respondent. In the present petition, two legislations of the Karbi-Anglong Autonomous Council has been questioned on the ground of the incompetence of the council to legislate in the manner which impinges upon the rights of the landholder. Rights of the landholder. The Karbi-Anglong Land and Revenue Act 1953. The virus of Karbi-Anglong Land and Revenue Act of 1953 and Karbi-Anglong Land and Revenue Fourth Amendment Act 1973 has been put to challenge during the preliminary hearing of this case. It appeared to us where is that Act of 1953? You had given it to us.
Yes, my lord, given.
Up in here. Or whatever I said. It appeared to us that the virus of the act is being questioned primarily for the reason of incorporation of a clause that the Assam Land and Revenue Regulation 1886 shall be applicable wherever it is required. Stop. The apprehension of the petitioner here is that with the incorporation of the Assam Land and Revenue Regulation 1886, the Autonomous Council shall usurp the powers of the state over the land, for which the council does not have the plenary powers to legislate, plenary competence to legislate. Before giving any finding on the aforementioned argument, we deem it appropriate to direct for listing of this case along with WPC 7211 of 2021, which is pending consideration regarding challenge to the eviction notice to the writ petitioner herein. Incidentally, the eviction notice is pursuant to Rule 18 of the Assam
Settlement rules of Assam Land and Revenue Regulation 1986.
Stop. List this matter along with WPC number 7211 of 2021 on. We keep it after 2 weeks, but
Any day on a fixed day, my lord?
fixed day.
Fixed day?
After 2 weeks, date will be given by them.
Oblige, your lordship.
12-8.
Yes, sir. All these should be.
Item number 6.
Yes,
My lord, this is with regard to large case irregularities and malpractice in the combined competitive examination 2013, my lord. So one-man inquiry commission was appointed by retired Justice Biplab Kumar Sharma, and this report was submitted, but a part report was given to us, my lord. They have given volume 1 of the report, volume 2 has not been
who
given.
appears for the state? Now, that grievance is one, but what have you done over this report?
Action taken.
I'm asking you, state,
Action taken.
action taken, yes?
Yes, so that we have to come up because today I don't have the complete instruction.
No,
But
we
as
understand.
regard,
Commission of inquiry,
yes,
the
yes.
recommendations are not mandatory. But in this case, it is pursuant to an order passed by court.
Yes.
So therefore, an inquiry was made by a judicial officer, by a judge of the court,
Judge of the.
and then certain suggestions have been given perhaps.
Yes.
Nonetheless, I mean, there is a report. What has happened to that report? You have kept it on, back burner.
No, report has been made public, but as regard the volume 2 of the report,
That is one thing. You can always hand it over to him.
as regard the.
You can do it today, you can do it tomorrow, but we are asking you, what have you been doing over that report?
After the report, it has been submitted
this is-
before
this is-
five-member
This
committee.
was with respect to competitive examination in 2013.
Yeah.
Now, in 12 years now, 12 other competitive examinations would have been held. You must have done something which you do not know. You can bring it on record.
So let me have my time.
But why this lackadaisical approach? This is for hearing. You should have anticipated this question.
So can it be taken up after some time? I will have my senior who is
Who is
leading
your
with the
senior?
matter. Senior in the sense, senior government council of government of Assam. So he is dealing with the matter. So he
He
might,
must be having his name, no?
yes, Dinath.
Tina. Here. This public interest litigation seeks a direction to the respondents for ensuring timely action by the state authorities in conducting examination. Ensuring timely action by the state authority in implementing the findings and recommendations made in an inquiry report which was submitted on 2nd of April 2022. Next paragraph. With respect to a combined competitive examination held in the year 2013 by the APSC, it was alleged that several irregularities were committed in concluding the process. There were charges of malpractice and corruption in the selection process. A writ petition was then filed by PIL number 79 of 2015, in which a direction was given to the government of Assam to conduct an inquiry into the alleged misconduct. In compliance of the aforementioned order passed by the court, a committee though was constituted, but only in 2019, which was headed by a retired judge of this court. The inquiry committee submitted its report in the year 2022. It appears that the report has been made public, but there is nothing on record to indicate that the recommendations were carried out for maintaining the purity of public examination. The learned counsel for the petitioner has laid a grievance that the entire report has not been given to him. The counsel for the respondent submits that the same shall be furnished to him within a period of 2 days. He has further prayed that the matter be taken up on some other day when his senior would be addressing this court. List this matter under the same heading on next hearing day. Next hearing day is Tuesday. Which day? Wednesday.
29. 29.
Tuesday.
29.
My lord, 29, I will not be there. My lord, let it be on 31st, my lord. Thursday.
31st.
Oblige.
Item 7 and 8.
Yes.
May I please, your lordship?
Yes.
My lord, the matter, my lord, relates to, my lord, a TET examination which had been conducted by the state of Assam, my lord,
Yes.
for the purpose of, my lord, recruitment of teachers in the various, my lord, provincialized madrasa educational institutions, my lord, existing at that relevant period of time. Now, my lord, the contention which we have raised before the learned single judge.
No.
My
That we'll see. What is the issue? First, tell us.
My lord, the issue
What
is,
happened? What is the cause of grievance?
my lord, the cause of grievance is that the government has said that the general TET qualification and this TET qualification as the course curriculum and syllabus are different. So therefore, both cannot be equated, my lord. Both cannot be treated as an at par. But my lord, we are claiming that as these institutions are at par with the secondary level as well as the elementary level, so therefore, my lord, there cannot be any distinction, my lord. That is
Which is that government notification which you had challenged?
My lord, if my lord may be pleased to take up item number, my lord, 8 is very clear, my lord.
Number 8.
Yes, that is the earlier writ appeal, my lord.
Yes.
Lord, the notification.
One second.
My lord. 2000.
Which page is it? The page
My
10/9/2020?
Five, five. My lord.
No, also the notification.
Notification will. Where is the notification?
My lord, the notification by which it had been cancelled is at 10/9. My lord. My lord, may be pleased to find that notification, my lord. My lord, at 162, my lord. This is the initial notification, my lord, by which on 5th of January 2019, my lord.
Where is this 21/11/18?
My lord, the 21/11/18 is, my lord.
21.
My lord, may be pleased to find this at page 29/11, my lord.
21/11.
My lord.
And page 162 is written as 21.
Yes, my lord. At page 100 and, my lord. 94, my lord, annexed 2, my lord. No, this is 29/10, by which it is allowed. My lord.
21/11/18.
Oh, my lord, 21/11, my lord. Dear, my lord.
Page 173.
Yes, yes.
Well, show us all the 4 notifications on which you claim on which you rest your claim. First, the notification of 3/8/2014, right?
My lord.
Put it at one place.
3/8.
Then 3/8/2014, the original, the TET examination for madrasa teachers.
My lord.
And the first one, when it began, thereafter 29/10/2018, 2/11/2018, when the same examination was permitted. I mean, people passing in such examination.
They were allowed, my lord.
Were allowed to be appointed
My lord.
in other schools, not
My lord.
necessarily madrasa schools. And lastly, the 2020 notification.
Yes, my lord.
You have to put it all together. That's for a different purpose.
My lord. My lord, may be pleased to find the notification by which the TET was
The earlier
conducted.
notification and the 2 subsequent notifications, they were only for the purposes of appointment. I mean, testing the qualification of people or appointment in provincialized madrasa schools.
My lord.
That could not have been the same condition for other provincialized schools, higher secondary school. And therefore, when this idea gained ground that without any qualification you are being appointed, the government came up with the notification rectifying its mistake.
My lord, in the madrasa institutions, my lord, in this.
Say it is the same.
Yes, my lord, the statute says, my lord. For that, my lord, I beg to draw your lordship's kind attention, my lord, to the Assam Madrasa Education provincialization. Yes, my lord, that is vital. The question my lord has put up. My lord, generally the madrasas, my lord, we have a feeling, my lord, that these madrasas are only teaching the theological subjects, my lord.
No, that apart.
My lord.
Madrasa may not only be teaching theological
Mal-
subjects, and they may be teaching general subjects.
Yes, exactly.
But the very intent of the advertisement issuing the requirement of TET, sometimes in 2014, then 2018 and 19, was for that purpose only.
No, for the purpose of, my lord, that is.
How could that TET examination be made applicable for appointment in higher schools, higher centers of learning?
Because, my lord, they have already appointed, my lord, similarly situated incumbents, my lord.
I mean, in service jurisprudence, principles of legitimate expectations, others may have been appointed, and therefore the necessity of bringing a cutoff date, not to touch the old ones, but to start afresh.
My lord, I am not claiming the negative equality also, my lord.
You
That- My lord, but the issue is that from the same class of persons, my lord, they have created two different classes, which they cannot, my lord. Now, my lord, to satisfy my lordship's, my lord, I beg
What
to,
class has been created?
my lord, from
That
this,
is a separate class which was pursuant to notification of 2014. The TET only for the purposes of madrasa education. That was unfortunately continued till 2019.
my lord.
So be it. So thereafter, the government came with notification of 2020.
No, my
Now,
lord.
how do you question the correctness of this decision?
No, my lord, it is not an unfortunate affair, my lord. It is a conscious decision on the part of the government, as because, my lord, the course curriculum and the structure, my lord, of these madrasa institution and the general schools, the syllabus, which the duties are required to be rendered by the teachers, my lord.
Are you aware that 50 years ago,
My lord,
no NEET or other examinations
No.
were held?
no, my lord,
You know, anybody passing ISC could
can be,
take admission in medical college.
my lord.
Can you think of it today?
No, that's
So
why, my
therefore,
lord.
the system of education is being upgraded.
That's why, my lord, this,
See, if you're not trained, if you don't have the qualification, if you don't pass the TET examination meant for present day employment, how
Well-
do you say that you've been carved out as a class from a class which enjoyed that? And who are the courts? I mean, do we sit and see the curriculum and the nature of examination which others had passed and which you are required to pass now? Can it be done?
as an expert, my lord. No, my lordship can examine, my lord, that whether the action of the government has violates the Article 14 or not.
No. Article 14 does
My-
not apply here. If you start applying Article 14 everywhere in these matters,
My lord,
this is with the passage of time. This is a fresh appointment process.
correct, me.
And where they say that no, henceforth we will not take. Suppose,
My lord,
I mean, I am giving you an example. Suppose today the hospital administration says, or the government in the health department says that we will only employ persons who have attained MD degree.
my
Now,
lord.
is it a breach of classification or Article 14?
No, that is.
Equality, I mean, that's a classification which is based on some rationality,
Reasonableness, my lord.
reasonable.
But here the principle of reasonableness and rationality also fails, my lord. Why I am respectfully submitting, my lord? If my lord may be pleased to take up the statute, my lord. That is the Assam Madrasa Education Provincialization Act, the definition part,
Suppose you try
My
and
lord.
demonstrate and you successfully demonstrate
my lord.
that in these madrasas also very good teaching is imparted. Nobody is doubting it.
My lord.
Nobody is doubting it. So you teach geography, you teach politics, you teach civics, everything all right. But then it is for the government to decide what qualification would they fix. You know the law, it is so trite that it does not require any repetition for the purposes of fixing a qualification. Even for creating a pool of persons from where the appointment could be made. I mean, those conditions could be fixed by the government only. You can say that it is irrational, but then you will not be able to prove it here. They require a fresh TET. Now, there are many states where you would realize that if a person passes TET, say 5 years ago, he would not be eligible. It has to be a fresh one.
My lord, in the state of Assam, this,
Therefore,
my lord.
we are not importing the other state's law or qualification here. Then other way.
My lord, what, in our state, my lord, this TAT pass candidate, the certificate is now.
Mr.
made-
Masudar,
My-
Yeah, Buyan. Buyan.
he's Buyan. No, where is Mr. Bakri? No, I'm asking.
Mr. Mazumdar.
Mr. Mazumdar, this has got nothing to do with this case. You just meet me for a minute at 1 in my chambers.
My lord. My lord, my respectful submission, my lord, before my lord is that, my lord, the statute says that these madrasa institutions and the general schools, my lord, are at par. Because the course curriculum and syllabus,
What I have been saying.
my lord, that's why, my lord, the TAT examination and the product which they have made from these teachers, my lord, are at par and similarly situated with the teachers of the, my lord, TAT examination which had been conducted for the general schools, my lord. That's why, my lord, the government took a conscious decision that as there is available madrasa TAT qualified candidates are there, they can be recruited in the general schools also, my lord. That was their one contention, and that's why, my lord, we have been allowed also. But only, my lord, 20,000 persons has been passed out in this examination. My lordship is well aware, my lord, that in the state of Assam, my lord, the government has come up with a policy, my lord, that this madrasa institution is no more in existence, my lord. They have been transformed into general level schools, my lord. Now, we are the candidates, my lord, who are expecting our appointment in these madrasa institutions. Now, we are nowhere, my lord.
No. They would be giving you some, relaxation of age for appearing in DT exam.
No, my lord. Again, we have all, my lord.
We can't go back to that 2014 notification.
No, my lord, we are already TET qualified, my lord. We are already TET qualified.
Saying, so that loses its force. That was for a limited purpose. It
No,
was
my
for
lord, it
teaching
is-
Arabic,
it is-
Hindi or
My lord,
whatever.
my lord, with all respect, my lord, what I am submitting, this certificate have a lifelong validity, my lord. Even these certificates can be used in some other purposes also, my lord. But the government,
Now try and understand this example.
my lord,
Suppose you pass an examination, a competitive examination, you get into the service. And the government, the employer thinks that there should be a midlife examination to test whether you are a deadwood or not. Or whether your services would be required. And they
Right.
require you to pass another
my
examination.
lord.
Can you question it?
No, my lord,
Can you question it? You can, but
My-
you will not be successful in questioning it.
no, my lord, the government has with all power and all domain within them to fix the eligibility criteria of the teachers, my lord. Now, but here is a case which is exceptional, my lord. Why I am making this submission, my lord? With all respect, my lord, what I respectfully beg to submit is that the product which the government has created, my lord, 20,000 candidates had been passed out. That the madrasa TET examination, and we are expecting our appointments in these madrasa institutions, my lord.
That is all right.
Now, my lord, the government come up with a policy abolishing this madrasa institution, transforming the same into schools, my lord. Now, the government says that as these are at par with the general level schools, so these madrasa TET qualified candidate cannot be inducted in the general schools also, my lord. But, my lord, the course curriculum and the syllabus by which, my lord, we were, my lord, gone through or our examinations were conducted is also similar with the, my lord, general level schools, my lord.
That general statement and comparison would not do. Yes, Mr. Saikia?
Lordship. Good. No, basically, Lordship, that whole advertisement for the TET was issued in the month of October 2014. And the advertisement very categorically said, this TET qualification examination is being conducted to have TET qualified persons who will be eligible for madrasa institutions also only. So nobody else had applied. Those who are interested for having a service career in the madrasa institution, they can only come. Identically, we have other TETs also for like we have 6 schedule areas where the level of education is little bit lower than the general areas. So we have 6 schedule area TETs. So those TET qualified persons are entitled only for recruitment in those areas. We have some Siksha Mitrans, Siksha Sarathi. We want to regularize them at one point, but without having that is not permissible under the 2009 regulation of the Central Government RTE Act, as well as other state statutes. So we conducted special TET for those Siksha Sarathi, Siksha Mitra.
That's right.
So wherever it is required as a eligible criteria that professional qualification have to be acquired, we are doing it. Here, the background is that why this advertisement was issued. One PIL came before this honorable same court, Lordship. And there the allegation is that I think my learned friend appeared in that case, if I'm not wrong. They said that in the madrasa institutions, all the teachers are not having TET. So the students are not getting deserving and qualified teachers. The students of the madrasas are suffering. Therefore, government took a conscious decision that we are going to do it because the general TET qualified candidates are not interested, may not be interested to go for madrasa institutions. Therefore, government started this process of having a madrasa TET qualified candidates, and therefore this advertisement was issued. So with their eyes wide open, Lordship, they applied and they got this certificate. Because of some mistake at one point of time in 2016 and 17.
18 and 19.
Yes, and that is also for a specific reason because we are not finding enough Arabic teachers. That is precisely the reason why government took that conscious decision to allow madrasa TET because they are teaching, they are qualified for those kind of subjects. In general schools, those subjects are optional subjects. So therefore, government took a conscious decision that madrasa TET qualified candidates are also allowed to participate for a one session, no? For one recruitment process. Then government realizes mistake because that is creating problem now. So there was no parity. As a result, the subsequent impugn notification was issued by uprooting the other two notification of 17 and 18. So 18 and
So have you given them some age relaxation?
thereafter, Lordship, 3-4 rounds of recruitment process is over. If they want, if Lordship directs, we can always do that. But now the system for higher secondary also is changed. Now the TET is not mandatory for the higher secondary. For so far as the elementary education is concerned, it is perfect, Lordship. It is required under the RT Act. In Assam, we introduced the TET for the secondary education also, which is not under the central legislation. But now we have abolished that TET and we are having written test or recruitment test at the time of recruitment process, Lordship. So we are taking 5 marks from the TET if they have already acquired TET. Otherwise, they will have to appear in the written test for the secondary education. But so far as the elementary education is concerned, Lordship, the same situation is going on. So they must have a TET, the general TET, not the BTAD area TET or 6th schedule TET.
Is there any age limit for appearing in a TET examination?
There is, Lordship, but otherwise also TET qualification is required for private institutions also. It is not that only for government schools only they have to have TET. Now under the regulations of the 2009 RT Act, the private schools also must have TET qualified. So in those schools, the age upper limit is not there.
Just find out and tell me whether for appearing in a TET
For TET,
examination, is there any age
yes,
limit? If not, then they go without-
in that advertisement, there was a specific mention. Yes, 38 years was the, but we are increasing it. Now it is 40 years.
No, the new notification under 20, in the year 2020.
Just 1 second, Lordship, we will get it. They can also appear in the central TET also. It is not that they have to appear in the.
It's true. Their concern is different.
Yes, the issue is different.
They say that in 2014, they passed the TET.
Lordship.
And that time there was no impression given that they shall have to appear in another TET. So they thought it for their life.
No,
Continued with their
when it
work.
was in 2014, the period was 7 years. Subsequently, we have increased it. But original TET in Assam, the first TET held, if I'm not wrong, it was in 2012. The certificate was valid for 7 years period.
Okay. So this 2014, he's TET of which year? Mr. Bhuya, your TET of which year?
2015.
2015.
Advertisement of
Where is the certificate? If in the certificate, it will be mentioned how many years it is valid.
Initially, it was 7 years.
Yes.
Milord. My respected advocate general is correct. Later on, Milord, by a notification, all the TETs, Milord, in the state of Assam has given the lifelong validity, Milord, if I'm not wrong, Milord.
Lifelong validity, all right.
My lord.
So nobody is snatching this
certificate.
Certificate.
But it is
Just
not,
that you're not getting an avenue of appointment.
no, my lord, it is not a redundant product, my lord. Why I am submitting, the madrasa institutions are not there.
Yes.
We have paid rupees 400 per person, my lord, to appear in the examination.
Giving you benefit, we can't sort of jeopardize the career of students, no?
No, my lord, we
And
are.
on top of that, they are not selected. The rest of their colleagues have all were selected and they are doing job.
No, selected by virtue of the TET of Madrasa, my lord.
Whatever,
My-
but they are
my-
already in the system. They are already recruited.
My lord.
So they are the leftovers.
Leftovers because not because they're less meritorious, but because they did not have the qualification. That way, Mr. Puhi is.
No, identically placed, identically qualified persons have were successful in the recruitment process.
How do you say then we dismiss it again? I mean, others who are qualified for only Madrasa TET, they have got into service.
Yes, yes.
Then you can't question it, no?
No, my lord, those
You have
persons.
participated, that was not the ground on which you were non-suited, you can't question it now.
No, my lord.
Else can
No,
question.
my lord, that is not the correct proposition, my lord. The learned single judge's order, my lord, which we are challenging,
No, tell me one thing.
my lord.
Now, with you, this is which examination, this is which employment notice that you are concerned with?
Yes, my lord, the advertisement of 2018, my lord.
Advertisement of
2018 and 19 is there, my lord.
Okay. This is for appointment of which teachers?
Appointment of teachers in upper primary schools of the general category, my lord.
Upper primary school,
My
so
lord,
general
that is
category.
up to class 8, my lord.
After class 8.
My lord,
Okay. So
up to, my lord, up to,
up to class 8.
my lord,
Direction of.
Up to class 8.
my lord.
So in this you appeared.
Yes, my lord, no, my lord, we have not been allowed to appear in the advertisement because there is a condition has been precedent that those madrasa, only the general category that first candidate
That's all right.
has been allowed.
Well, Mr. Saikia said something else. He said that you
No.
participated, you failed.
No,
and
no,
therefore
no,
you
no,
are
no,
the
my lord,
left
we have been debarred, my lord, and that debarment was under challenge before
No,
the
no.
learned single judge, my lord. And the learned single
Then-
judge has
then
held,
you
my
have-
lord.
Then you have the locus to challenge it. That-
My-
there's no
my lord.
difficulty.
My
Yes.
lord, there are other aspects are also there, my lord. If my lord may be pleased to hear on some other day, I can satisfy, my lord.
But today we are concluding it now.
My lord, some,
Which other
my lord, the issues which I want to, my lord, respectfully back to submit is that the distinction which has been carved out by the state that these madrasa institutions are different. My lord, only a little bit of course curriculum, my lord, has been in the theological mode, my lord. Otherwise, the rest of the syllabus has been followed by the at that relevant period of time, Board of Secondary Education, which has been prescribed for the general schools.
we are least qualified to make that comparison.
No, my lord,
We are least qualified, for posts for certain posts in the government. The qualification fixed was diploma.
no, my lord, I do not.
Serious challenge was laid
My
that
lord.
they are not permitting graduates.
No, my
Saying
lord,
that diploma and graduation is a higher degree, diploma is a lesser degree. Therefore, this would include if a lesser degree is the benchmark, is the threshold, the higher degree could always apply. The High Court said, Supreme Court also said no. Unless the lesser degree is subsumed in the higher degree,
My lord.
unless it is in the same channel of education.
My lord.
Such comparisons now saying that diploma is 3 years, graduation is 5 years, course curriculum is the same. Why not? These are not the issues which are justiciable. We are not saying this. This is the line of judicial precedent which
No,
tells.
lord, I do not have that courage to submit before my lord that my lordship has not the expertise, my lord. It is the, my lord.
No, none of us.
My
None
lord,
of us. They're
my lord.
specialists. Mr. Saikia would also not have the expertise. His officers will have.
But that is the
His
mistake
government
they have,
will have.
that is the mistake they have done, my lord. The authority which have fixed the syllabus has not cancelled and has not come to a conclusion that this qualification and that qualification is different. The TET examination is conducted by an expert body, my lord, and the conclusion which came before the, my lord, government is by some other body who is not expert in the field, my lord.
That is a different question altogether. Then you question the correctness of this, but not your ouster from participation. Where is the incompetence of the government to come out with a notification that this tet would be necessary
That
for
was,
further.
that was averred before the learned single judge, but learned single judge has, my lord, also discarded that point also, my lord.
Rightly, sir.
Because, my lord, the issue which has been raised,
And Mr. Bhuya,
My lord.
legitimate expectation is something which is not to be applied here.
because, no, my lord, legitimate expectation initially was not there, my lord. But when the some of the persons, my lord, similarly situated has been,
Not in 2020,
no,
not against the advertisement of 2018-19.
no, it is before that, my lord.
So
Before
therefore, you're not similarly placed.
No, my lord, the same schools, my lord, the same schools.
It's all right, Mr.
My
Bhuya.
lord.
Suppose you would have participated, you would have wanted to get into the school in, say, against advertisement of 2016. Perhaps you would have sailed through.
My lord, there is no,
This is a distinction which has a rational basis, no?
my lord.
They come up. If you say that in the against the advertisement of 2018-19,
My lord.
some persons with Madrasa Tet have been entertained and I have not been, we will strike it down here and now. If you
No,
say
my
so.
lord, in 19 and 20 also, my lord, those Arabic post has been, my lord,
Again,
allowed.
Arabic is something different. Arabic is not general education. Arabic could be compared with the Madrasa Tet examination.
But my lord, in Madrasa Tet also, what they, if my lord, just for a moment, I'm sorry, my lord, I'm taking some time before my lordship, my lord.
No, it's always a pleasure to hear. You are responding to every objection of the bench. This is very heartening. No
My-
difficulty.
My lord,
No difficulty.
my lord.
We get irritated only when same thing is repeated. You're not repeating
No,
it.
my lord.
You're answering.
My lord.
Yes.
My lord, may be pleased to take up the syllabus or the notification of 3/8.
We will hear you again on the next appointed date.
My lord, my lord.
Hearing to be continued. Hearing to continue further. Relist under the same heading on next week.
31-7.
My lord, any day, my lord.
31-7.
Obliged, highly obliged.
For hearing, item 9 and 10.
Yes.
My lord, before my learned friend begins, Lordship would see that there are two proceedings here. One is a contempt and one is a writ appeal. In the writ appeal, I am the respondent, but then formally the notice is yet to be served on us. The contempt we had filed, my lord, for non-implementation of the single judge's judgment. Now, since both have been tagged together, my lord, we have come to know, we have intimated the client, my lord, and shortly the colornama will be filed, my lord.
You're in which matter? That contempt is in which matter?
Item number 10.
Contempt is 10, madam.
No formal notice has been.
No, Lordship,
This was issued not received,
this
my lord.
court accepted that service is complete, Lordship.
Notice petitioner takes step to the same. Service is complete.
My lord.
Service is complete.
It was
I can
deemed,
serve an extra copy to my
it was
friend.
deemed to be complete, my lord.
So, but what do you want?
My lord, I want the copy to be served, my lord,
I
because I have to
understand.
formally appear, my lord.
I will serve an extra copy, Lordship.
In the connected contempt case, number 697 of 2022, the notice has been received, but the copy of the petition has not been served upon the respondent, upon the.
No, the copy, along with the copy we have served, I will serve an extra copy.
All right, then we only adjourn it. You serve it,
My lord.
then we don't say anything. There has to be a reason for adjournment, as prayed for, re-notify all these matters on any other hearing day.
My lord.
When?
After a week?
Next week?
My lord.
31-7.
Applied. Well, not on 31, my lord, any other bit.
Take it in August.
My lord.
5th of August.
Deeply applied.
We can permit you to argue even without wakalatnama.
My lord.
To be furnished later.
My lord, it will come. Otherwise I was ready, my lord. It was a short issue.
The only difficulty is that your client may want some other lawyer.
My lord.
You really don't know. All right.
Item 11.
Yes.
An appeal against the judgment of the Honorable Single Judge, my lord, dismissing my repetition, my lord, on two grounds, my lord. Firstly, my lord, that there was no vacancy, and therefore the state level scrutiny committee was right in rejecting my recommendation. And second, my lord, the direct single judge took into consideration that a long time has already elapsed. My lord, but in my respectful submission, my lord, that time could not have been attributed upon me because I was pursuing my remedies before the court, and the repetition was pending since 2015 to 23, my lord.
No, but.
If your lordship may kindly.
Just a minute.
My lord.
1 minute.
My lord.
My father died in 2010. Rejected due to want of vacancy. In 2015. And here filed is only
No. Then thereafter, you consider.
After that, no, because rejected.
Even then, he was attending the. Let's see the impugned judgment.
My lord. All of the judgment starts from page 73. The finding of the Honorable Single Judge, my lord, will find on page 77 from para 9.
It's complete. Yeah. Yes.
My lord. Page 77, paragraph 9 onwards. My lord. This is a third round of litigation, my lord. The initially, my lord, the district level committee recommended.
1 second, we'll just get back to you.
Yes, yes. I'm sorry.
Yes.
Madam, the petitioners for appointment for compassionate appointment was recommended by the district level scrutiny committee in 2010 itself.
Yes.
So thereafter, the state level committee to give a consideration in 2013, Malad sought for the financial status from the district.
Yes.
Thereafter, Malad, the first petition was filed in 2014, Malad, wherein when this matter was listed, it was informed to the petitioner that his case was rejected by the SLC. Malad, he thereafter filed a petition challenging the rejection of the SLC. Malad, this honorable court set aside that order of rejection, Malad, that your lordship will kindly find at page 52, the first order, Malad, interfering with the rejection, Malad. Page 50 starts from page 51. The relevant portion at page 53, Malad.
Yes.
Malad. The on that first rejection was that it went on force because of 2 years, no consideration was given. Thereafter, as per the direction of this honorable court, it was again placed before the SLC, but SLC rejected for want of vacancy. Whereas, my lord, on the date when the SLC took into consideration the office memorandum which was holding the field, my lord, that is 1st June 2015. That office memorandum provides, my lord, if there is no vacancy in that concerned department where I have applied for, then the department should explore the vacancy in other department, my lord. That's a principle laid down in the office memorandum. This aspect of the matter was never been considered by the SLC, my lord. Though, my lord, on the day when it was given a consideration, this office memorandum have superseded all the other prior office memorandum, and this was the office memorandum holding the bill. I have placed that office memorandum. The lordship will kindly see one principle 10 clause 15, my lord.
Yes.
So that exercise was never been done by the state level scrutiny committee. internal page 6 of the office memorandum, clause 15.
Mr. Counsel, the difficulty here is this.
My lord.
Now, despite that OM, that OM doesn't talk of exploring any vacant position. The vacancy which corresponds to the earmarked vacancy for compassionate appointment.
Well.
And the earmarked vacancy is only 6 or 7 for the entire state of Assam. So therefore, the exploration aspect would have been considered only if there were vacancy meant for compassionate appointment. See, all posts cannot be filled up by compassionate appointment. You know that.
Right.
Now it is not the source of appointment. It is
Very good.
only
Correct.
for relieving providing succor to the family in distress. So in that case, with the passage of time, even otherwise we would not do. In fact, they should have been very prompt. But now you must have come of age. Where would you be accommodated? Even if we take a very, very liberal view, where would you be accommodated? Tell us.
True. Well, that's
You would have lost out on age, and you have survived for all this while. So everything goes in the background. We are very careful in dealing with issues of compassionate appointment because more often than not, it has been the experience of this court that there is deliberate delay on the part of the government. But here it is not like that.
Here it is.
It was only in the first trance that the state level committee sat for 3 years. But otherwise, the court granted you that relief, set aside the order of the district.
And directed to consider my case with regard to the existing vacancies. Well,
Existing vacancies was a very vague term. Existing vacancies earmarked for compassionate appointment.
True.
So therefore, that would not have helped you.
Malad, the earmarked vacancy, malad, the vacancies earmarked for particular department. So therefore, my lord, the clause 15, your lordship will kindly see
That is
clause
a
15.
misnomer.
My lord.
Unless you sort of consider it as existing vacancy in the department for compassionate appointment. Suppose there are 20 vacancies.
Yes.
20 vacancies would not be filled by all compassionate appointees, no. Earmark 5%, 3%. Many states have only 2%. Some of these states say that no, we give you a lump sum amount, but we can't accommodate you in
Here
service.
we have a policy of 5%.
The 5%.
5%, malad, therefore, malad, that it happens actually. Therefore, the government by this clause 15, malad, had made a provision that if the appointee, the applicant who are in the waiting list should be given a consideration in respect of the other departments as well.
Nothing can be done now.
And since the writ petition is pending since 2015 before this court met.
But Mr. B. Kaushik, learned advocate for the appellant, and so.
P.N. Goswami. P.N. Goswami.
P.N. Goswami, learned additional.
Advocate general.
Additional
Advocate general.
AG for Assam. They had claimed for compassionate appointment on the death of his father, who died in harness while working as Havildar in the excise department in the district of Lakhimpur. Immediately after the death of his father, wherever I have said petitioner, say appellant. The appellant made an application seeking compassionate appointment through the superintendent of excise Lakhimpur. He was recommended to TOO, and his name was placed before the SLC, which did not do anything in the matter for another 3 years. Vexed by this, the appellant had approached this court for a direction to the SLC to consider the case of the appellant. But by that time, it was discerned that on 11/6/2014 only, the case of the petitioner was rejected by the state level committee SLC on the ground of there being no vacancy in the department. the appellant withdrew the writ petition, but again challenged the decision of the SLP on the strength of the OM, which mandated that in case there was no vacancy, effort should be made to explore the vacancy in other department so as to provide succor to the family of the deceased employee. The writ petition, this writ petition was disposed of for a reconsideration of the case of the appellant by the SLC. Against the existing available vacancy in the post of excise constable, earmarked for appointment on compassionate ground. The case of the appellant was reconsidered, but again rejected on the ground of non-availability of vacant posts for the year 2014-15. The learned single judge, while dealing with this case, took note of the fact that it was brought on record, took note of the fact that from 2008 to 2012, there were only 6 numbers of posts were reserved for compassionate appointment throughout the state of Assam, which had already been filled up. The directions issued by the writ court of considering the vacancy position as against the claim of the appellant could not have been sustained in any other manner except for finding out the vacancy position of the earmarked posts for compassionate appointment. That apart, the death took place in 2010. The appellant has now waited for about 15 years to seek appointment on compassionate ground. It is too late in the day to reiterate the principle that compassionate appointments are in a way a departure from the general provision providing for appointment to a post by following a particular procedure of recruitment. It cannot be and is not a source of recruitment. The schemes under which compassionate appointments are made have been framed to provide succor to the family of the deceased in distress. The concern of the employer is that the family should not be forced to the brink of starvation with the death of the earning member of the family. Death of earning member of family, which brings in its train financial crisis. After having said that, there is no gainsaying that appointment on compassionate ground could be treated as a source of recruitment. It is not a vested right which can be exercised at any point of time in future. Speaking generally, compassionate appointment cannot be claimed or offered after a lapse of time and after the crisis is over. Though all efforts should be made to immediately redeem the family in distress, and it is highly improper to keep any such case pending for years. But in the present case, when 15 years have passed by since the death of the employee, it would be absolutely difficult for this court to differ with the judgment of the learned single judge in rejecting such a claim. In rejecting such a claim. The whole difficulty appears to have arisen because of the delay made by the state, delay made by the SLC in considering the case of the appellant. This perhaps has frustrated the very object of the scheme of compassionate appointment. We are constrained to observe that such lackadaisical approach on the part of the government authorities has resulted in a suitable claim of a person for compassionate appointment go waste. Government officials must act with a sense of utmost proactiveness and immediacy while deciding claims of compassionate appointment, so as to ensure that the wholesome object of such a scheme is fulfilled. Coming back to the arguments advanced on behalf of the appellant, that the order passed by the writ court for exploring the vacancy position at the time of the appellant having made an application, we can only say that the vacancy position has to be seen in the context of earmarked vacancy for compassionate appointment. Even if there is a vacancy in a department, but the earmarked vacant positions are full, it would be very difficult to accede to the request of the claimant to seek compassionate appointment. In any view of the matter, as noted above, since 15 years have now passed by, the hands of the clock cannot be turned back. Not for the reason of any. That's what it cannot be, the hands of the clock cannot be turned back. By this time, the appellant must have even crossed the age of appointment. Though with some regret, we dismiss this appeal and sustain the judgment of the learned single judge.
Well, may I indicate one thing? There is a judgment of this honorable court directing the SLC to sit in every 3 months.
which they never follow. That is why this has happened.
Therefore, we have said.
Yes.
Grateful.
Item 12.
Yes, Mr. Bhuya, you are again here?
My lord, my lord.
Yes.
My lord, this is a matter, my lord, of selection and appointment of teachers in my lord Boruland Territorial Council, my lord. My lordship is well aware, my lord, that the Boruland Territorial Council has been created, my lord, as a sixth schedule area in the state of Assam. A particular district has been earmarked. And there are some certain transferred subjects, my lord, which the council has the jurisdiction and the governance, they can decide on their own. Lord, irrespective, despite that, the finance is required to be funded by the state of Assam. That's the issue. Now, here is a case, my lord, wherein a selection process has been initiated and wherein we have been selected by way of a select list. Now, my lord, basing on that select list, initially the appointment, that select list had been put into challenge before this honorable court. My lord, and this honorable court, my lord, did not interfere with the said select list, my lord, and it was a direction to go ahead with the recruitment process, my lord. And thereafter, my lord, although there is a direction, but we were not appointed. Then we came before this honorable court, my lord, with seeking a mandamus that we should be appointed. And accordingly, my lord, from that select list, my lord, we had been appointed. Subsequently, my lord, the government suo to take up the issue that our selection was not in accordance with the rule, my lord. So therefore, my lord, the government has just merely issued a so cause notice. From basing on this so cause, a reply has also been, my lord, furnished by us. And basing on that, my lord, our services has been all were terminated, my lord. And those terminations orders, my lord, were again assailed before the my lord, before the honorable learned single judge, my lord, and the single judge has upheld, my lord, that my lord, termination of the petition.
Let's see the impugned judgment.
My lord. My lord, may be pleased to find the judgment start. $395, my lord, the judgment starts at. My lord, can skip, these are the cost title, my lord, that the operative part starts from page 407, my lord.
One second, give me 1 minute, Mr. Bhuya.
My lord. Let me see the one.
There is no record. There is no record. At that possible. It happened in the schedule as well.
Well, everything was over. Mr. Moya, it is shocking. It's like Alice in the Wonderland. So many orders were passed in different proceedings in the court, yet there was no record of any advertisement, no record of what had happened, no record of the select list. But the courts were continuously passing orders.
That's the issue, my lord.
But then
That's the issue, my lord. The
it's
custodian,
substantiated by record.
my lord, that's the custodian of the record, my lord, with my,
But then they have raised their hands. I am seeing it for the first time. It doesn't happen in a
court
in an
proceedings.
administered state.
My lord.
Maybe because of the council, sixth, because of the Bodoland, governance method.
My
I
lord,
don't know.
my lord. No, they have a directorate, my lord. The director of education is there. My lord, for controlling the managed and the education affairs, my lord.
But if I had seen it in my state, I would have been constrained to ask the education commissioner to come
My lord.
and explain how this happened.
But my lord,
But
life,
then in this scenario, whether the single judge was wrong in dismissing your claim.
my lord,
It's a writ
the-
petition, no? Suppose it were a criminal case, the pleadings could have been asked for, the documents could have been asked for.
benefit of doubt can be, my lord, given, my lord.
Here, you have to prove it, no, you couldn't prove
But
it.
my lord, may kindly appreciate one thing, my lord.
We quite understand.
Six-
Otherwise, if it were all sham,
My lord,
you would not have come to the court. You would not have been appointed.
my lord. My
But
lord, one,
somebody challenged your appointment and therefore everything was stayed. This is also surprising that nobody was questioned.
My-
Nobody was, nobody was summoned. Nobody was noticed, none of you,
no,
all 61 of you.
no, my lord.
Therefore, there appears to be something very fishy in the entire transaction.
My lord, fishy, my lord.
On what ground can a court of law decide that, well, since there was a direction to consider and appoint them from the select list, that select list is nowhere in picture. We do not know where this
No, select list was there, my lord. Select list was here
But
also.
select list made out of what? Which process?
Select,
Which interview?
my lord, the interview wherein we appeared, my lord. My lord. Huh? My lord, even one affidavit has been filed, my lord, by the same director, my lord, wherein they have stated categorically, my lord, that the appointment were made pursuant to the record available before them, my lord. Now suddenly, my lord, they have to make a U-turn, and when our appointment, when we challenge our termination, they have said, my lord, that they do not have any
The
record.
time is gone.
My
You
lord.
should have told the learned single judge
My lord,
that time that please initiate action against the officials.
my lordship
The
can,
records have been lost
my lord,
or they have been destroyed. Whatever. There could have been a judicial inquiry
my lord, my lord.
because, or not for the reason of your getting into the job and then being shown the door, but for the reason that there was a High Court's order.
That's correct, my lord. My lord, sometime, my lord, even
Calls for a CBI inquiry or something. But definitely no interference with the judgment of the learned single judge. If there is nothing on record, suppose if there is no warrant of appointment available with the government or with me or with the state of Assam, what Chief Justice I am?
no, my lord, with all respect, my lord, what I beg to submit, my lord, my lord is that the,
You know, I mean, let me tell you a very interesting fact.
my lord,
A person masqueraded as a judge, passed many orders in the criminal side.
my lord,
Those were executed. And after 4 years, it was decided that he was a fake person.
my lord,
I have seen that happening in my state.
it happened, my lord. One case I have
Not
also.
usual, but appointment process like this. He had, I mean, of course, he masqueraded as a judge of lower jurisdiction.
My lord,
He was
my
a
lord,
civil judge, junior judge, civil division, junior judge.
my lord. But my lord, here is a case, my lord, for the fault of the government.
No, it is not the fault of the government.
No, my
Mr.
lord, the
Bhuyan.
fault of the council, my lord. They are not
Not-
maintaining the record.
So this is a peculiar situation where nothing can be done. You've lost it. It is in thin air.
But my lord, if my lord may goes through the judgment, the learned single judge has held that though our appointment entry into the service, my lord, is also not in accordance with law, and the exit was also not in accordance with law. Now, my
So
lord,
therefore, it cancels out.
no, my lord, therefore, my lord, once we became a government employee, my lord, rightly or wrongly, my lord,
This is indicative of it evinces fraud. Fraud vitiates everything.
rights, my lord, once we became a government employee, some rights.
Who can pass an order? Tell me the most liberal of the judge cannot pass any order other than what has been done by the single judge.
My lord, can we be, my lord, subjected to a proceeding, my lord? Disciplinary proceeding, my lord.
That period is gone. You disciplinary proceeding of what? Why? The initial appointment is doubtful. What proceeding? Nothing is there on record. I've never seen a fact like.
My lord, the initial appointment is based on a select list, my lord. Those select lists we have.
Select list you make how?
No, we
All
don't.
people make them stand in a line, enter their name.
No, my lord. The interview was there.
Show us the advertisement.
My lord, may I please to find the.
There's nothing.
My lord. Additional affidavit of this, no? My lord, at page 103 of my petition, appeal memo, my lord. It is a notification, my lord. It is hereby
How
not.
many of you have preferred the appeal? 61 of you.
My lord,
All 61 of you.
all 61 million. All families are looking at my lordships, my lord. Their families. Oh, my lord, very pathetic condition, my lord. These are very down to road families.
Under what provision, how, with
My lord, I know. We should,
what a strength.
my lord. In accordance with law only, my lord, can be.
Otherwise, it will not be sustained.
My lord.
Passing an order, I mean, we can't do as BTC has done.
My lord, I can understand. Lord, my learned friend has apprised me that one suo motu case regarding this selection and appointment is pending.
Let it take its own course. Your rights shall not be extinguished by dismissal of this appeal. If there is any suo motu inquiry or something is happening,
my lord,
they will see what happens. But this appeal can't be decided otherwise, no? We're surprised. And we are surprised not with the circumstance, but with the fact that twice the courts have passed orders.
Mandamus is there, my lord. And those order has not been interfered with, my lord. And even the learned, my lord, respected learned single judge also, my lord, has not, my lord, interfered with those orders, my lord.
Take that. This is an appeal in a very strange set of facts. We have heard Sri A.R. Bhuyan, learned senior advocate.
No.
Learned advocate.
Only learned advocate, my lord.
You are senior in your own rights. You don't need a silk gown to be
My-
called a senior.
My lord,
We are looking up at you as a senior advocate.
my lord.
Learned,
Obliged.
A.R. Bhoya, learned advocate for the appellant, and Mr.
S. Bora.
S. Bora.
For BTC.
For
BTC. Woodland Technical.
what are you doing?
Madam. I have told the record, I have presented the record also, my lord, on the, before the single, that nothing was there at that. Original was not there.
Record to be fulfilled.
What have I said? Set of facts. In a very strange set. Upar mein likho, they have heard so and so. This is an appeal in a very strange set of facts. The appellant's claim that against an advertisement issued in the year 2002, they had applied for being selected / appointed on the posts of assistant teachers in schools of all, in schools under Buxa district, falling under the territorial and administrative jurisdiction of Bodoland Territorial Council. Bracket hereinafter referred to as BTC. Their names found mention in the select list. Since the recruitment was not being made against the select list, the appellants had approached this court and obtained a direction that the appointments be made from the select list in order of merit, but subject to the reservation policy. Pursuant to such a direction, the appellants were appointed some of the persons who were not recruited laid a grievance against the appointment of the appellant and filed a writ petition before this court, in which an order was passed sometimes in 2016 staying the appointment orders of the appellants. Thereafter, the Director of Education, BTC, had issued notice to the appellants asking them to reply as to why their appointment orders be not cancelled. And later, by separate orders, the appointment of the appellants were cancelled. challenging the aforementioned termination / cancellation of the appointment of the appellant, they came up before this court by writ petition number WBC 6328 of 2018. The learned single judge, however, found that the BTC asked the appellants only to furnish documents to substantiate their claim that they were appointed against a regular process, as there was no official record of any such process having been undertaken in the past. Though an effort was made to procure evidence of the process having been initiated and the appellants having been declared successful, but there was no corresponding record in the office of the Education Department of BTC. In the records of the Education Department, the only document of substance which was available was a notification for advertisement. After giving a thoughtful consideration over the matter, the learned single judge, expressing his regret that neither the appointment of the appellants nor the cancellation of their appointments could be said to be justified, concluded that there was no record of any employment advertisement which would have had in any manner, which would have had in any way reached out to the public or anything to suggest that the process was undertaken on which date. Right from the beginning to the end of the process, of the recruitment process, there was no record. As we said earlier, this is not only a strange, but pathetic state of affairs. The learned single judge could not have passed any other judgment in these set of facts. Mr. Bhuya learned advocate has submitted that the employer is the custodian of records. And merely because the records of the recruitment process not having been preserved in the office, there cannot be any insinuation of fraud on the part of the appellant. The blame should only be thrown on the employer and not on them. So under such circumstances, the learned single judge, it has been argued, ought to have extended the scope of hearing of the writ petition and should have called for a report from the respective department of BTC or should have ordered for an inquiry in the matter. We inquiry in the matter. However, we are of the view that if an inquiry would have been directed, the issues would have been laid bare and it would have been and the male factors, MAEL, male factors in the whole process would have been detected as a strike that off. We are of the view that in a case of this kind, an inquiry should have been conducted as to how there was in existence at the time when the matter had reached the court for the first time, a select list against which no recruitment was being made. Later, the attention of this court was drawn in another writ petition challenging the appointment of the appellants. When, on certain considerations, the operation of the appointment orders were stayed. It was only thereafter that inquiry was made from the respective appellants about documents to prove that the appellants had participated against a recruitment process and had come out successful. We do not know who is to be blamed. However, under the circumstances, as we have already noted, there was no way, there was no other way in which the learned judge could have decided the case. We, expressing our surprise, dismiss this appeal and only observe o tempora o mors.
Oblige, my lord.
Mr. Bhuyan, you're coming up with different kinds of cases.
My lord. Oblige, my lord.
Attempt 13 and 14.
Lord, I am praying for a short accommodation, my lord, for these two matters, my lord.
There should not be back-to-back dismissal, no.
No, my lord, in the morning I have informed my learned friend.
As prayed for and agreed to, as prayed for on behalf of the appellant and agreed to by the respondent, the matter is adjourned to 2 weeks.
My lord. Obliged, highly obliged.
19-8.
My lord.
Item 15 to 17.
Yes, okay. Yes.
May I please, your lordship? So this is again an appeal by the state against the.
It's an appeal by the state, yes.
My lord. Against the judgment and order passed by the honorable single judge. The short issue which calls for consideration here is that in view of the constitutional bench decision in DS Nakara, where it has been.
Yes, Nakara, you have gone so behind, huh?
My lord.
That holds true, and that will hold true for many years to come. Let's see the interim judgment.
Yes, my lord. Lordship may kindly come to page 118 of the memo of appeal.
Give me 2 minutes.
My lord.
Yes.
So taking a cue, my lord, from what has fallen from P.S. Nakara, pensioners,
Withdraw the appeal.
my lord,
Why did you withdraw the appeal? This is a review judgment,
Yes, review,
judgment
madam.
that isn't challenged.
no, my lord, initially we had filed a writ appeal before this.
Therefore, we are asking you this.
Yes, my lord. Now,
Basic settled facts need not be reiterated. When I am putting a question to you, why did you withdraw the appeal?
my lord, it was withdrawn because it was transferred,
Because the court insisted.
my lord, something like that.
And therefore, you should have told the reviewing court that we withdrew the appeal on the asking of the judge.
That was, my lord, placed before the review
What can
court.
be done?
That
The
was
law with
placed-
respect to review is clear.
Absolutely.
You can again file an appeal. And what is this one class for persons who retire for 3 years?
No.
That's all?
No, no. In between 1/1/2006 to 31/3/2009.
Right.
But because of the financial constraint prevailing at that point of time, and my lord, the law laid down by the apex court, my lord, in Amarnath Goyal, that was skipped, my lord. We couldn't have placed it.
Show us Amarnath.
Yes, my lord. 2005, 6 SCC, my lord.
Who appears for the respondent? Ready?
2005, 6 SCC, 754, my lord. Lord, people will kindly peruse from paragraph 26 onwards, my lord.
Paragraph?
Paragraph 26, my lord. 26, 27, 32.
In fact, Mr. Counsel, you would have been well advised had you taken the advice of elders. I mean, elders means some second advice that, appeal was withdrawn for you to file review.
My lord.
Review was not maintainable, review was dismissed. Instead of filing an appeal against that order dismissing your review, you should have gone in appeal again.
My lord.
That now there is no way out, this injustice has been done. And there it was not considered to be an error apparent on the face of record, and therefore review was not maintainable. You should have straight away come against that order again. Review. So before appeal, suppose you had not gone in appeal, you had of your own gone in review.
My lord.
And review would have been dismissed. Would you not have filed the appeal against the main order?
Absolutely, my lord.
So therefore you go again.
No, my lord, here.
Why do we do it? Financial constraint, all right, but what happened? Was the order complied with?
My lord, contempt.
It has been, contempt is pending.
My lord. But here in the appeal, my lord, apart from challenging.
Tell me one thing, what has happened then? This dates back to 2009.
My lord.
2006 to 2009. Are the persons alive? They must have retired that time, 2009. How many years have gone by? Who is pursuing it? And you must have given that payments to them.
No, my lord, if Lordship will kindly appreciate that the revision in pay was notional. In fact, no actual payment had accrued, my lord, had gone into the account. And
Counsel,
Lordship, in
again, this is the confusion which you're creating.
my lord,
Notional hike
my lord,
was for the purposes of was that you would get that benefit, but it will only be for the purposes of computation of your pension.
my lord,
That is notional.
that is. And my lord, in
You
this,
don't get any arrears of salary, but notionally you will be entitled to that salary.
my lord,
But my lord, both you are saying, my lord,
my
in
lord,
both the cases.
that calculation, my lord, areas will spring up. Exactly, my lord.
So that, whether it is sprung up or not, but that is the situation.
Yes, no,
So
my lord,
therefore,
coming to the relief,
they
my
are,
lord, my lord.
what has happened in contempt? You have created a bad situation for yourself.
Now, my lord, in this appeal with all respect, my lord, apart from challenging the order on review, my lord, we have also challenged the original order passed in the repetition also, my lord.
You have challenged it.
Yes, my lord, in the relief part, my lord, prayer portion, my lord, at page 32 of the memo of appeal, my lord, with all respect.
Hello.
Memo of appeal in the beginning.
Yes.
Not late.
In the beginning. Okay.
Where is the memo? Just
No, it is, yeah. Starts from. Writ appeal 418 of 2023.
My lord.
But out here you asked for setting aside judgment passed in the review petition.
No, my lord, page 32, my lord.
Ah.
Page 32, relief, first relief is, my lord, to set aside and quest the impugned judgment dated so and so passed in review petition. The second relief is, my lord, to set aside and quest the impugned judgment and order dated 28/4/2016 passed in WPC. This is the original, my lord.
all right. You are saved temporarily.
Now, my lord, I will be failing in my duty.
Page 20?
Page 32, my lord.
Yeah, it's after the term.
On top of the.
Okay. Should have found part of two appeals, not one.
So this appeal is against the review order.
But both review and as well
That
as
you have done by, this is also notional. Where have you impugned the judgment of the London single judge?
that is of course not here, my lord. We have also
Okay,
paid,
therefore,
my
that's
lord.
what it is, same thing like notional. Put it on record. How do we hear the appeal and set aside that order? Review, we have no quarrel with the proposition laid down by the London single judge, right? You were wrongly advised to come and appeal against the order passed in review. That you have done this comes to your rescue now. But this means nothing unless you impugn it. Where do we get that judgment?
My lord, the judgment is a part of the record, my lord. Possible just now, see, of course, my lord, we have not placed a certified copy, but it is there, my lord.
File an affidavit,
My lord.
seek permission, say that if, this judgment now in this circumstance is being impugned, we hear you later. And also consider whether would the state like to file this appeal now after such a long period?
My lord, I take it, my lord.
I think, sir, I think this appeal is against the review judgment
review as well as, my lord, the original.
The appeal, but वो कहाँ है, किया ही नहीं है, he has not impugned it, he has just made it, no certified copy, nothing. They will first raise objection on this. So therefore I say that file an affidavit, seek permission, convert this appeal, or you convert this appeal into an appeal. Ask for make a prayer for converting this appeal against the impugned judgment, against the judgment in the writ.
My lord, let me file an interlocutory application in that regard. And so apply.
Here. I threw that shit. Take it. Take it.
Page 32.
Some facts have to be stated, no?
Yes.
Okay.
In a writ petition, bracket WPC 61 of 2011, a challenge was laid against the classification a challenge was laid to the decision of the government in not paying the arrears of salary to employees who retired from 1/1/2006 to 31/3/2009 on grounds of financial stringency. Despite acceptance and implementation of the recommendation of the Assam Pay Commission 2008 with effect from 1/1/2006. In that writ petition, a learned single judge, relying upon the judgment of DS Nakara and others versus Union of India, 1983, 1 SCC 305, held that such notional classification was not permissible in case of pensioners who formed a class in themselves, especially when the recommendations were implemented with effect from 1/1/2006. For employees who would have retired prior to 1/1/2006, there would be naturally no benefit of the hike in the pay. But only for financial stringency, persons retiring between 1/1/2006 to 31/3/2009 could not have been denied the benefit of the pay commission recommendation of higher salary. This anomaly was further confounded by there being no specific statement that the stringency, the financial, straightened financial, the straightened financial circumstances of the state would be overcome after 3 years. Would be overcome after 3 years. The state of Assam challenged such a decision in appeal and cited, where is that book? Amarnath Goel. And cited, Amarnath Goel ki kitab, decision. And cited the decision of the Supreme Court in state of Punjab and others versus Amarnath Goel and others, 2005, 6, SCC 754, wherein it was held that financial constraint is a valid ground for fixation of cutoff date for grant of benefit of increased quantum of pay or other post-retirement benefits, other pay or other benefits. However, the appellant state of Assam withdrew that appeal in order to approach this court, in order to approach the learned single judge in review. The review petition, however, was dismissed on the ground that there was no error apparent on the face of the record or something which could not be discovered without a long drawn process of reasoning. Reasoning. What have I said? I've said review is dismissed. Review petition was. In the present appeal, along with the order dismissing the review petition, the order passed in the original writ petition also has been impugned. But the order passed in the writ petition, but the certified copy of the order passed in writ petition has not been brought on record. Even otherwise, two appeals were required to be filed separately. Nonetheless, the learned counsel for the appellant submits that he would be filing necessary affidavit with a prayer for impugning the judgment passed in the writ petition also in this appeal by the next date. In order to enable the appellant to do so, we accede to his request and post this appeal on after 3 weeks.
21st August.
I'm so obliged, my lord. My lord, the other two connected matters are slightly different. They have challenged, my lord, the policy decision of the state.
All the matters, the other two matters shall be listed along with that.
My lord, I'm so obliged.
Item 18.
What? What I am giving you money. But income appealing.
Yes.
May it please, Your Lordship. Lordship, in this matter, I had challenged a recruitment rule of the Numoligo Refinery Limited, Lordship. That is a public sector company, Lordship, working as a joint venture with oil.
Just a minute, give us a minute.
Lordship.
Please take your seat, we'll call upon you.
Lordship.
It's a public sector undertaking, no?
Lordship.
And which provision of the recruitment policy? These are only guidelines or
Lordship,
statutory?
in fact, Lordship,
It's a statutory rule. But
Lordship,
nonetheless,
in fact, initially I didn't know that they had certain rules, Lordship. But the honorable single bench where it was first filed, Lordship, they said, bring the rules how you make the recruitment. Then they brought out the rules, which is at page
and
47, Lordship.
therefore this writ petition before the division bench. You've challenged the
Lordship,
constitutionality of the rules.
After I got
All
the
right,
rules,
show us the rules now.
Lordship, it is at page 47, Lordship.
I have serious reservations whether you'll be able to. Page 47.
Lordship, relevant part is page 49, Lordship. Clause 7, Lordship. process and procedure of recruitment.
That's permissible. That is permissible, sir.
Lordship,
That's
Lordship.
permissible. Show me the law.
Lordship,
Article 16 permits it.
Lordship, I have certain directions from the. Yeah,
Check up the case law on the subject.
Lordship,
It has been decided long time ago.
Lordship. একটু মূলটিটা কি হবে?
These are no restrictions.
Lordship, recruitment, they are making only through the employment exchange, particular employment exchange.
Through particular employment exchange.
Lordship,
That's right. So this restriction
Lordship,
is also open to competition. So people.
they are not
employment
doing it,
exchange,
Lordship.
They could have also gone for only recommendations from employment exchange.
That cannot be done, Lordship, as per directions of the
Which direction?
Lordship, that I have placed before your Lordship, Lordship.
What direction? I am asking you to bring the case law on the subject. I don't think so.
2011,
Constitutional
3
provisions
SCC
mandate
434.
that this could be done. No? Judgment, sir.
Which one? 35, 36? Which paragraph?
Lordship, it is of 2011, 3.
No,
Which one,
paragraph,
Lordship?
paragraph.
Para, Lordship, page
This is
440. Paragraph J, Lordship.
thing altogether unless there is some statement. Yes.
Paragraph J 440, paragraph J, Lordship.
Paragraph
Eh?
Lordship may come to page 440.
440.
Education and universities, Lordship. You may find at J, serial number J.
Then you are referring to plus items.
Lordship
Not like
and,
this, not like this, sir.
Lordship and page 451,
Not like this, Mr. Bhagavati.
Lordship.
J.
And paragraph 35, Lordship.
Paragraph 30.
35, 36, that's the.
Lordship. 35, 36, Lordship.
Please turn on capital. One page is missing. Therefore, I was turning the pages. Right after
I'm sorry
paragraph,
for
31,
that.
there is paragraph 36, no 35. And see 450, page 451 is missing. देखेंगे आप लेकर
Lordship, SCC 2011, 3 SCC 436. Lordship, in fact, Lordship, initially, Lordship, this honorable court had directed them, the NRL authorities, to Lordship, not to give effect to this recruitment rule. That is the order passed on 22/5/2024 in this case only, Lordship. 22/5/2024. Two 2011, 3 SCC.
लिखता है कि balance.
law clerks, even with respect to law clerk from only national law universities of people assembly. Which I said it.
Yes, paragraph 35 says the part of the. We'll have to get back.
Lordship,
Paragraph 35 says stop.
Lordship, and Lordship, this honorable court, Lordship, by an order dated 22/5/2024 had stayed the operation of that sub-clause, Lordship. And
So thereafter what happened? How was the recruitment?
subsequently, they made an amendment, Lordship. Amendment to the extent that instead of 100% reservation for Golaghat Employment Exchange, they made reservation for only 30%. 70% was made open to all.
Then why do you question?
Lordship, even
Then
if,
why do you question?
then Lordship, even if 30%, no, if your Lordship permits, I have nothing to say. But Lordship, if your, it should be according to the guidelines framed by the Supreme Court, Honorable Supreme Court, Lordship. Lordship, 30% reservation also would mean that reservations are made.
This is no reservation. It is only limiting 30% from employment exchange, rest by advertisement to public at large.
Lordship.
He has not challenged the 30%.
If Lordship.
Your challenge is only to the 100%.
Lordship, I had challenged it to
Your challenge is not to the 30%.
not to the 30%, Lordship. I have not yet challenged that part, Lordship. But if your Lordship permits, Lordship, I can challenge that part also. But since the matter is pending before this honorable court, Lordship, and during the pendency of this case, they made the subsequent amendment, whether it would be necessary for me to again challenge it, Lordship. Because Lordship, once they go for that 30%, that would mean that they have taken the due consent of this honorable court, Lordship, for 30% also.
No. So where is that order which is still operating?
Lordship, it is in their affidavit in opposition, Lordship. Okay, in opposition. Page, it starts from page 76, Lordship.
You want to stay order? Page 22/5.
Their affidavit, Lordship, page 76. And the relevant part is page 79.
424. 9/4.
Justify for 30%.
Again, one portion is reflected in page 79, Lordship. Clause 7.
No, but they're not sort of giving effect to that amended clause.
No, not yet, because it was
That's
before
the
this,
operates.
before,
Therefore, they have
because
to
it was before this honorable court, Lordship. That was placed before this honorable court.
That's right, we'll decide it the next day. Whether this can be. And what affidavit have they filed? Who appears for the refinery? Yes.
First of all, minor lordship, let's see the order dated 4/12.
Forget about those orders. The court had asked you, don't complicate the issue. The court had asked you for offering justification for instead of 100%, why did you not remove it totally?
Lordship, we have
You read
explained,
the order.
we have explained it para 3 and 5, my lord. Para
5 of your affidavit, 5
Yes.
when?
File, same thing, same, page, Lordship may see, page, start from page 70, my lord, down below, my lord. Para 3 and para 5, my lord.
No development. This is satisfactory. Satisfactory. Yes, ma'am.
Lordship. For that part, Lordship, I had filed my reply, Lordship, to their affidavit.
Reply.
Page 87, Lordship.
But why do you want to go to that no development zone of Kaziranga?
Lordship, that I am explaining, Lordship.
No, where is the reply?
That part I have explained in paragraph 7 of page 87, Lordship.
Read that.
Lordship, that as regards the statements and averments made in paragraph number 3 of the affidavit in opposition, this deponent begs to state that the declaration of no development zone by the Ministry of Environment, Forest and Climate Change as referred to in the affidavit in opposition
So that's
is,
it.
Lordship,
No development
Lordship may allow me to continue for 1 minute, Lordship. That the by the Ministry of Environment, Forest and Climate Change as referred to the affidavit in opposition is actually meant to prohibit any activities within the periphery of 15 kilometers of Kaziranga National Park, so that the eco-sensitivity does not get disturbed by the wildlife situated within the national park. As reflected in the affidavit, the purpose was not to restrict livelihood of anyone, but to protect the wildlife forest of the Kaziranga National Park. Next, Lordship. Kaziranga National Park is not restricted within Golaghat district alone, but it covers parts of 3 different districts, namely Nagaon, Sonitpur, and Golaghat. The park's periphery also touches Karbi Anglong district, Lordship. 4 districts, Lordship, it touches. So why only Golaghat, Lordship?
Right.
Very specific, Lordship, very specific. This is for Lordship has not, I don't know whether Lordship has gone to Kaziranga. Lordship will see that this zone, that Kaziranga and this Numoligarh refinery is quite apart.
We appreciate your argument. Your argument is that the reason given by the refinery for even keeping 30% reservation does not, it defies logic.
Lordship.
Because if it is a no development zone, let others also come, that is to their peril. But why? Limited to the graduates of that area.
Lordship.
That doesn't make sense.
And not the whole area, Lordship. Lordship may see only for who get their name registered in the employment exchange, Lordship, not the whole people of the whole district.
The difficulty here is that
some people may not register their, Lordship.
you have shown a judgment to us, but I have also seen a judgment which says that this kind of classification can be done for a particular reason.
Lordship.
Anyway, we'll see it on the next day.
Lordship, I have given 3 judgments.
You know, judgment for photostat. Photostat all 3 judgments. Keep it on the next day. Now, since it's an interim order, we have to. Yes, we must deal with it on the next day. Let this matter come up. Arguments to continue further. Re-notify on just next Tuesday. When Tuesday?
I'll be out of station.
You will be out of station, but then you should be the first one to have this restraining order removed. Otherwise, how would you appoint?
Only for the Tuesday accommodation, my lord, only.
Thursday.
Obligement.
ये किताब की photocopy
जी जी जी
Mhm. 31.
The rest of the three matters on the next date.
My lord. Actually, these are all covered cases, anyway, my lord, next day.
No, no, if it's a covered matter, you.
Yes, yes.
Yes, follow.
yes.
Try to get.
In fact,
Item 19 to 22.
for my line senior pen starts, I was praying for an accommodation today, in this one.
All right, so as prayed for on behalf.
That will be in the next week.
Next week, anything.
As prayed for on behalf of the respondent, next week.
31/7.
Thursday. All right.
31.
Grateful. Malad.
Deeply.
Well, thank you so much, Mr. Kant.
My-
My lord, I'll just, will not on 31st, maybe little 2 days later or earlier, my lord. Yes,
Give your date, Mr.
29th, my lord.
No, beyond 31st.
Okay. इधर के जो है, it can be on the 6th, my lord.
6 Wednesday. Not a hearing, gentlemen.
7.
Or it can be 5th.
Yes,
Is that a hearing day?
5th is hearing.
No,
5th.